Welcome to Classic Trials. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we make sense of the law one bite at a time. In this series, we observe and analyze the play-by-play of some of the biggest trials that have shaped the public consciousness of the American judicial system. In this season, we're working our way through the case of California v. Erik and Lyle Menendez. Growing up in Princeton, New Jersey, and then Beverly Hills, California, these young men had everything they could ever want, or so it seemed, until one night on August 20th, 1989, they approached Jose and Kitty Menendez with newly purchased shotguns. Put on trial for murdering their own parents, they claimed self-defense, arguing they were terrorized in their own home by abusive parents until they could take no more. Which argument is more convincing? Come join and see for yourself. All right. Good morning, good afternoon, good evening. I hope that you all are doing well wherever you are, whatever time it is. I hope you're having a good Monday. I hope you had a good weekend. If you celebrate Easter, I hope you had a great, wonderful Easter. Let's see where folks are coming in from. Let's see. Oh, first off, we have a new member, need a new name. Thanks so much for becoming a YouTube member. And welcome to Bite Club. So if you are available on Friday, we've got our members only casual live stream where we're kind of just hanging out and chatting and sometimes talking about law, sometimes not. And it's just a nice way to sort of roll into the weekend. So I hope to see you there. And welcome to Bite Club. More Mountain Princess 207. Hey, all checking in from Maine. Hello, Tony P. Good morning. Hope everyone's having a magnificent Monday. Same to you. Night Eyes, good afternoon. All good afternoon to you. Living life with and singing songs with Mallory. Hello, everyone. Kit Kat says, hey, everyone. Mew Mew 0203. Hey, Alita. Hey, everyone. Sending love from Tokyo. Oh, I love it. I love it. Let's see. We've got some more, of course, every time I do this. Hello, Alita. This is Sandra Ramirez. Hey, Sandra. Hope you're doing well. We've got CJ Drake. Good morning from Pennsylvania. Oh, and Mallory's coming in from Utah. Wonderful. And we've also got Bronwyn W. coming in from Utah. Good morning from a finally warm and sunny Utah. That's awesome. Jackie Crow. Hello from Portugal. Mary M. Easter greetings from Munich. Elise Lynch, good morning, all. Good morning. Blessed Mommy UV4, good morning, all. Happy Monday. Happy Monday to you as well. And we've got a couple more. Why not? Ray Zafar Nejad. I really hope I pronounced that correctly. Good morning from State College, Pennsylvania, working on my PhD thesis. Everyone have a great week. Wonderful. Good luck on that. I'm sure that's a lot of work. Gina D, good morning from Boca Raton, Florida. Oh, and also nice reminder from Secret McSquirrel. Thank you, Secret. Reminding us if you are watching the live chat, set it to live chat instead of top chat so that way you can see everybody. I don't know why it does that by default, but I always forget. So it's really nice to have that reminder. So thank you, Secret. Otterly Bell from Sweden. Hey guys from Sweden, just in time to keep me entertained while touching up my hair. I love it. All right. And Paige Willow, a question here, late to the party. Why are they having another trial? Good morning. So this is not a new trial. This is our classic trial segments. We are transporting ourselves back to 1993. Let me show. Yeah, 1993. I'm like 92 or 93. Either way, when Alita was baby Alita, very little. So I don't remember this trial really at all. The first big trial that I remember happening is the O.J. Simpson trial. And so I just remember because my usual programming on TV, which was kid shows, were not running. And so that's basically why I remember it. But anyway, we're going through this old trial. And so, oftentimes people talk spoilers, so I'm sorry to anyone that is new to this trial. It's often in the chat, and so anyway, so if you do know what resulted from these trials ultimately, because there were two of them, and spoiler alert, this was the first one, which when there's more than one, usually it's because there's a mistrial. So this is the first one and the only one that was televised is my understanding. So we are still in the plaintiffs. I mean, this is episode 17 and we've been doing this in like anywhere between 2 to 4 hour blocks. And so we're still in the plaintiffs prosecution's case in chief here. So we have listened to a lot of testimony from Dr. Jerome Oziel. So for folks that are just dropping in, don't really know much about this case, basically one of the big reasons why the prosecution was able to even bring this case against the brothers is because they were able to not only find out about, but admit into evidence the essentially confessions by the two brothers to their therapist. And there's a doctor-patient privilege, of course, that has been talked about quite a bit. Now, that was an issue that went up to the appellate court and came back down from the appellate court. And basically the California Court of Appeals said it is admissible because the doctor has a psychologist has the ability to disclose the information that was disclosed to them by the patient, so long as it is they have a reasonable belief that their life or the life of someone else is in danger. So, not only do they have the ability to disclose, but they also have a duty to disclose as a result of that. So, anyway, so that's how we've gotten to this much testimony with Dr. Oziel, who is that psychologist who they apparently confessed to, and he turned around and told a bunch of other people. And his girlfriend, who is not his wife, but his girlfriend, who his wife knew about, I guess. I don't know. There's a lot of weirdness going on here. And his girlfriend, who he may have also given psychology he may treatments also. So there are all kinds of like ethical weirdnesses in this guy's practice and this guy's testimony. And it's my understanding that after this trial, he was no longer able to practice. And I believe that was a result of this trial. But he was already on probation to begin with before this, apparently. So this is all stuff that came out in previous testimony, and including last week, we got to part 4 of his testimony. I thought it was going to be the last bit of it. And then we listened to the psychologist who was his like probation officer. I can't remember exactly how they put it, but basically he was assigned to Dr. Oziel to oversee his practice because of the fact that Dr. Oziel was on probation for some shadiness with the ways that he was giving services to another patient, and then also doing a weird exchange of like work for work essentially, which is not okay under the rules apparently. The ethical rules for psychologists. And anyway, so we heard from this other psychologist who was overseeing his practice basically at the time. And there were some things that some questions were asked of him, and he gave some answers that indicated that he was kind of finding things out on the stand about some of the things that Dr. Oziel was doing, which he did not seem very thrilled about, but he kept very professional. So we'll see what happens now that Dr. Oziel is coming back onto the stand. This is part 5 of his testimony now. He's had so much time in front of this jury, and I don't think that he comes across as a very warm, empathetic person. He comes across as a bit of a narcissist. He comes across as and when I say narcissist, I'm not using any kind of like psych treatment definition for that. I am saying like he seems like a very self-involved person. And he doesn't seem to have very much empathy. He doesn't seem to have very much warmth. He's a very cold and calculating person is the way that he comes across to me personally. So this is my own opinion, my own impression. You guys let me know what you think in the comments, or comments if you're watching on replay, or in the chat if you're watching live. But yeah, Sandra Ramirez, she was a baby bites at the time. I was indeed. I was a baby bite when when this trial was going on. And yeah, so anyway, that was a total interruption. Sorry, caught my attention. And Tony P, cold and calculating is perhaps more than he deserves. Maybe. But or better than he deserves, you say. Yeah. So yeah, he gives me the heebie-jeebies for sure. That's just me and my own impression, my own gut. And yeah, the throuple situation is weird. It's a little weird. Yeah, and I'm sorry, Elise. Yeah, we've got some more Oziel. We've got like 6 hours more, 7 hours more of Oziel, and then I think we're done with Dr. Oziel. But I will say, as much as I don't like him, his testimony has been pretty entertaining. So there is that. And apparently Bright Eye says that it's going to get worse today. So that's great. So okay. So I think it's going to be Dr. Oziel today and probably Dr. Oziel next week. And hopefully that's it. So we should probably get moving with it. Shouldn't we? Let's do it. Right. And yeah, I know, LaQuaria, that's a lot of time testifying, testimonying. It's Monday. It's a Monday. It's fine. We're rolling into it. And yeah, but happy to have you guys here with a Menendez Monday. Gamer Ducko, good to see you here. And yeah, we've got Indy with us as well. So for those of you that aren't familiar, this is she looks like a little box of shadow, but this is my chocolate lab mix, Indy, also known as Indy Bear, kicking pillows off the chair so that she can get nice and cozy, and wait patiently for her food, which will be like, I don't know, when Mr. Bites gets home. So, okay, let's get into it, shall we? Let's do it. Okay. Let me know if there are any issues with the sound. As always, want to make sure that things are going well with
Dr. L. Jerome Oziel.
And this will be a redirect examination conducted by Mr. Kuriyama before both juries. Yes.
Dr. Oziel, I'm going to show you what's been marked as Exhibit 110. You recognize that?
Yes, I do.
Is that your curriculum vitae?
It's an outdated curriculum vitae, but it is a curriculum vitae. That's
what do you
correct.
use a CV for?
Well, a curriculum vitae is really
so we're actually on redirect now.
Statement that somebody who's in the academic profession tends to use to summarize the data that allows someone to know what they've accomplished and achieved in their academic
TJ
career.
Drake, you caught this before I did.
The purpose.
Now, in cross-examination, the defense went over selected parts of your CV with you, correct?
That's correct.
There are parts that they didn't go over.
We're fine.
They didn't go over the vast majority of it.
Okay. For example, you were honorably discharged from the Army in June of 1968.
That's correct.
You received your bachelor's degree in psychology from the University of Washington.
Who cares about his CV? At this
That's
point,
correct.
You received your master's.
We've heard so much weirdness about him. Who cares about him getting out of the Army in 1968?
That's correct.
You received your PhD in clinical psychology in 1972 from Arizona State University at Tempe.
That's correct.
That in 1971-72, you received the Letter of Distinction in Doctoral Comprehensive Examination from Arizona State University.
Yes, I did. I think as I recall, I received the highest rating or distinction among all doctoral students.
And in 1972 to 1974, you were the assistant professor at the University of South Carolina in their Department of Psychology.
That's correct.
And in 1974, you were the assistant professor at the University of
Really
Southern
trying to
California in the
rehabilitate
Department
him.
of Psychiatry and the Allied and Behavioral Sciences in their School of Medicine.
That's correct.
And in 1980, you were the associate
Anna,
professor of psychiatry, and you
Hang
were a
on.
tenured professor, correct?
So sorry, I'm going to pause right here because this is a good question. Anna Costello, don't they have to go through all of their credentials? So this is a good question. Generally, I mean, when we're talking about someone that is an expert witness, yes, they're going to go through all of the credentials because they either are going to be doing that for the purposes of qualifying this person as an expert or to show to the jury, this is why you should listen to this person's expertise, is because they have all of this experience. So even if they've already been qualified as an expert by the court, like the judge is like, yeah, it's fine, this person is an expert, they're still going to want to go through a lot of that stuff so that the jury understands this is somebody worth listening to. And if you have seen or heard any of the juror interviews since the Gwyneth Paltrow trial, for example, that was a big deal for them, or at least for that juror in particular that I saw. I saw one juror making an interview. I wasn't sure if there were more than one, but she said that one of the most convincing things for her was Dr. Scher, that the doctor, the biomechanical engineer that was so impressive to me, who was not only talking about physics, but he's super trained in physics and specifically physics in snow sports. So she was like, this is exactly the person that I want to be hearing from, is somebody who is going to tell me what's up and what's down in this kind of specific situation. So having that little bit of information about his background was very, very important to her so that she would actually listen to him above other experts. So anyway, so when it comes to an expert like this, a witness like this who is not an expert, it's not really as important for his testimony, except for the relationship that he had with the defendants, and also to show that this is a professional. He was doing things that were proper. This is someone who you can trust to tell the way that things happened, right? Because we're not listening to him for his expertise in psychology. We're listening to him for what he says actually happened. Is he a credible witness, a fact witness for what happened? But right now, what's going on is this is redirect. And usually redirect is where you're trying to rehabilitate any sort of points that were taken on cross-examination. So this is when, cross-examination. So sorry, let me start from the beginning. Direct examination is when you are telling the narrative through this witness. You are saying, this is what actually happened. And then on cross-examination, that's when the other side comes in and just kind of takes apart the picture that you painted and is like, no, okay, it's actually like, that's like, here, let's peek behind the curtain, right? Or let's pop under the hood and see what things really look like. And then on redirect is when you're like, okay, they made that look kind of bad, but let's show how it's actually not as bad as what they said. So this is what they're trying to do here, is they're trying to rehabilitate this witness by going through his CV and saying, like, you're this professional, right? Like, you've been through all of this training and like you've been a psychologist for a long time. And it's because on cross-examination, he was made to look so unprofessional, with going through how he was on probation, and then also the question of whether or not he had an improper sexual relationship with a patient, his girlfriend, who he says he didn't give any sort of medical treatment to, but there's a doctor's note that indicates otherwise, that shows that he's giving a diagnosis of her. So for the jury, that can look really bad. So now they're trying to make him look professional. They're trying to sort of like patch him up again. And by going through, his CV in such detail, it really shows that like they are, I think he was really just kind of taken down quite quite hard during that cross-examination. This is kind of what this is signaling to me.
Yes, I received tenure at the university.
At the University of Southern California Department of Psychiatry and the Allied Behavioral Sciences.
That's correct, I did.
Now, when you first started to see the defendants in October of 1988, what was the nature of your practice?
The nature of my practice was actually family and relationship therapy, in addition to the treatment of phobias, sexual disorders, and anxiety disorders. But one of my licenses is in marriage, family, and child counseling. And in fact, I co-directed a clinic in the Department of Psychiatry at USC, which was the sex therapy and relationship counseling clinic, which includes family therapy. And I taught and trained psychiatry residents, interns, medical students, nurses, and a number of other professionals, such as social workers and some staff members, in the performance of relationship therapy, in addition to the performance of behavioral therapy in relationship to treating depressions, phobias, obsessive compulsive disorders, and other anxiety-based disorders.
Generally speaking, as part of your practice then in 1988, did you, as part of your practice, treat adolescents with behavioral problems?
Yes, I did.
Now, is your wife Lulow Oziel?
Yes, she is.
And is she also a psychotherapist?
She is.
And during the period of time of 1988, around 1988, did she share office space with you?
Yes, she did.
Okay. How long has she been practicing as a psychotherapist?
Approximately the same amount of time as I had.
Now, do you share office space? Do you also share billing, people that do the billing for you?
Yes, we do.
And is she more involved in the billing aspect of your practices?
She's almost totally involved in the billing aspect of my practice. Deals with that with whatever secretary is employed there. I have very little, if anything, to do with it.
With either the billing or the secretaries?
That's correct.
Okay. So your wife is more involved in keeping of the books, et cetera?
That's correct.
Okay. Now, recently, were you in the process of moving your residence without telling us where you've moved?
Yes, that's correct.
Have you placed a lot of your records in boxes?
There are a lot of things that we have in boxes that we have not unboxed.
Is there going to be a follow-up question to that?
While teaching at the University of Southern California Medical School in the Department of Psychiatry, you indicated that you were a co-director of some clinic?
Several clinics.
Several clinics?
Yes.
What were those clinics?
The clinics were the anxiety disorders and the behavior therapy clinic, and also the sex therapy and relationship therapy clinic. Those are the two clinics that I co-directed in the outpatient department of psychiatry at USC.
You've testified from Exhibit 97, some records of billing in this case. And with respect to that, may I approach, Your Honor?
Yes.
I'll show you what's been marked as Exhibit 97, billing records.
Mhm.
In being examined from those records, you indicated that you had contact with Mr. and Mrs. Menendez, that is Jose and Mary Louise Menendez.
Yes.
What was your impression about Mrs. Menendez in your conversation with her?
You're on under objection on adequate foundation.
That is,
Sustained.
Yeah.
did you actually see Mrs. Menendez on September 30th, 1988?
I'm sorry, did I see Mr. Menendez?
Mrs. Menendez.
Mrs. Menendez? To the best of my recollection, I did.
So did you see both Mr. and Mrs. Menendez on that day?
To the best of my recollection, I did.
You've testified in cross-examination what your impression was of Mr. Menendez. What was your
Objection,
impression?
that mistakes the evidence. Is asked for remote.
All right, the objection is overruled.
Did you, all right, did you like Mrs. Menendez?
Yes, I did like Mrs. Menendez.
And what was your impression of Mrs. Menendez?
Objection, Your Honor, no foundation.
Overruled.
My impression of Mrs. Menendez was that she was a very bright, educated, sophisticated woman who was extremely protective.
Objection, Your Honor. If we're going to get into content, I'd like to be heard.
The objection is sustained. The question relates to the impression he had of her as a person, not any thing she did, just the impression you had of her as a person, similar to the impression you had of Mr. Menendez that
Defense
was described
doesn't
by
want
you.
mom
Your
to
Honor,
The
get
objection is
humanized
sustained.
too
The
much.
answer is stricken.
I'm just asking the court for clarification. In my view, that was part of my impression of her. I'm not sure how to segregate the two.
All right. Why don't you rephrase the question then?
What impression did you form of Mrs. Menendez based on what you saw of her?
Same objection.
All right. Not in relationship to other people, just as to Mrs. Menendez as a person.
Her individual personality
Yes.
characteristics. Okay, thank you, Your Honor. That she was very passive and anxious and depressed and just not very efficient or fulfilled as a person. So there was a very
Your Honor,
big.
I'm going to object to this as expert opinion with no foundation.
Ooh,
People have indicated they did not call this one.
that is
So
starting.
let's not argue the matter. The witness is being asked to give a personal impression of
That's a little
the
tricky though,
witness,
coming from a
not as
psychologist.
therapist
I understand
or a
Leslie Abramson's
psychologist, just your own
objection.
personal impression of the witness.
I'll ask another question, Your Honor.
All right.
Did you like Mrs. Menendez?
Ask the answer.
Overall,
Yes, I did.
Now, were Mr. and Mrs. Menendez patients of yours?
No, they were not.
About October of 1988, you started to see the defendants in this case, correct?
That's correct.
And the exhibit that you have in front of you, the billing records indicate when you first started to see the defendants. Is that correct?
That's correct.
You were asked many questions about that particular exhibit. I'm going to ask you to take a look at the entry for August 18th, 1989.
I have that.
What does that indicate, that entry?
It says, canceled short notice, Eric.
Now, on that day, were you made aware of why the cancellation took place?
No, I was not.
Eric Menendez didn't tell you that he was going to go down to San Diego to buy a shotgun?
Your Honor, that's.
objection overruled.
Excuse me, may we approach?
Objection overruled.
You may answer, Dr. Oziel.
Is there a foundation that he even spoke to Mr. Menendez?
Objection is overruled.
Oh, he is.
Um,
He's like, did I
The answer
stutter?
is no. Eric definitely didn't tell
He's
me
not
he was
having it
going
with
down to
Leslie
San
right now.
Diego to buy shotguns.
Sometime after August 18th, 1989, did you find out that Mr. and Mrs. Menendez had been killed?
Yes, I did.
And sometime after, well, do you recall when it is that you found out that they had been killed?
I think the first time that I found out they had been killed was actually, I had, I don't know if I was home or phoned home or whatever, but Laurel, my wife, said, my God, I'm just watching TV.
Objection, hearsay.
The question was when or how?
Actually asked when, Your Honor.
Okay.
When?
The objection is sustained. The answer is stricken. The
Yeah.
question is, when did you find out?
Yes, I believe it was the day that it was reported on the news, whatever date that was.
Sometime on or about August 23rd of 1989, did you have a conversation with Eric Menendez?
Yes, I did.
And what was the nature of that conversation?
Objection, I want the copy.
What was the date?
August 23rd, 1989.
We have the foundation as to whether Lyle Menendez is present, and if not, I would object.
Okay, let's have you approach here and we'll discuss it briefly.
Okay.
All right, let's resume with the redirect examination.
Dr. Oziel, we were talking about the Bel Air Hotel. And when it was that you first had contact with Erik Menendez after the killings of his parents. Do your records, Exhibit 97, indicate that you saw the defendants, both defendants in this case, on August 23rd, 1989?
Yes, they do.
Now, you were asked in cross-examination why it was that you went to the Bel Air Hotel. Is that correct?
That's correct.
And you were attempting to answer that question and you were stopped. So I'm going to ask you the question.
All right, let's not review rather the testimony. Just ask the question rather than going back on what did or did not happen during the cross-examination.
Very well, Your Honor. Why is it that you went to the Bel Air Hotel?
Erik and Lyle had requested that I come to the Bel Air Hotel to be with them from a professional standpoint, to counsel them and help them out with anything that arose that was emotionally difficult. But the reason specifically I was asked to go to the Bel Air Hotel as opposed to seeing them in my office is because I was told that the mafia might have a contract on Erik and Lyle, and for their safety, it had to be absolutely secret where they were staying, and there was a lot of security about it, and that they couldn't emerge from the Bel Air Hotel to see me in session.
Who is it that gave you that information about the mafia?
You know, I saw Erik and Lyle the day before, and I don't remember whether it was Erik or Lyle, but I definitely and distinctly remember the content.
It was one of the brothers?
It was one or both of the brothers, but I could not state certainly which it was.
Now, you were asked if you had gone to the memorial services for Mr. and Mrs. Menendez. Did you attend the services?
Yes, I did.
Did you charge the brothers for your attendance at those services?
No, I did not.
And so the charges that were made when you visited the brothers at the Bel Air Hotel was for sessions that you conducted there?
Consultation before or after the services, not for the services.
Now, you've testified that a day or two before you actually saw Erik Menendez on October 31st, 1989, that you received a call from Erik Menendez?
That's correct.
And would you describe for the jurors the nature of that call?
The nature of the call was that Erik called me seeming very distressed and said he needed to see me for an extended session, that it was really important that he see me as soon as possible. He told me that he wanted to be absolutely certain that he was the last patient of the day, that there was basically an open-ended amount of time to see him so that he could stay as long as he needed, and that there'd be no other patients present while he was there. And I don't recall, he may have indicated he wanted to go for a walk at some time during the session or wanted to leave the session at some point. That was the conversations I recall it.
And did you schedule him or see to it that he was scheduled for a late appointment on that day?
I did schedule him for the last appointment of that day, did schedule him such that no other patients would be present, and did schedule it open-ended so that I had as much time as possible or as he needed for me to talk with him.
Now, referring to the sessions of October 31st, 1989 and November 2nd, 1989, in which Erik Menendez confessed, and those sessions in which you were threatened, you were asked whether you kept notes at the time that those sessions were occurring, and you indicated that you had not.
Overruled.
Is that correct? You did not take notes during those sessions?
No, I did not take notes during those sessions.
Was there a reason why you didn't take notes while they were confessing and threatening you?
Yes, there was.
Why?
I'm going to object to the questions and states.
Objection overruled.
I didn't take notes because I was completely preoccupied with the threat, the trauma, and trying to determine how to cope with the situation that was confronting me.
And you dictated notes about a week later after the November 2nd.
Sustained.
When was it that you dictated these notes?
Between a week and 2 weeks. I can't be certain exactly which day it was, near the time, if not the time, that I purchased the shotguns.
And you've been testifying with the aid of a 20-page transcript of your verbal notes from that tape?
That's correct.
Now, you were asked on cross-examination about confidentiality, and you were asked why you told the secrets of the brothers. Now, a question that I have for you is it your understanding that generally speaking, what a patient tells a psychotherapist is privileged under the California Evidence Code 1012?
Yes, that is my understanding.
Now, would it be fair to say that this privilege, however, is not absolute?
Objection, Your Honor. This is leading on the witnesses.
All right, the objection is overruled, but if you can refrain from leading the witness.
So he's like,
Is
he
it your
overruled it, but
understanding
not
that
really.
there are exceptions to the privilege?
Yes, it is my understanding there are exceptions to the privilege, a number of them.
Do you know how many exceptions there are to this privilege?
I don't recall the exact number. I don't know if it's 11 or 12, but the most common ones that are used in psychotherapy there are about 4 of them, I guess, that are commonly used.
In particular, the exception that you saw applying in this case was which exception?
Well, the dangerous patient exception.
And what do you know what the evidence code section is for that?
I think that it basically states that in the event that
No, the question was as to the actual code section number. Is that what you're asking?
Evidence Code 1024, is that?
And as a psychotherapist, you're familiar with that section.
Objection, leading.
Overruled.
Yes, I am familiar with the section.
And what is your understanding of that section?
With respect to the dangerous patient exception?
Yes.
Yes, that in the event that a patient is deemed to be dangerous to himself or to others, that there is no confidentiality or privilege. That's the understanding that I have.
Prosecution really wants to hammer on that. The
Now, after
idea
the
that he was
initial,
afraid
of
the Menendez brothers.
with the defendants on October 31st, 1989. Would you recount for the jurors what it is you did after the defendants left?
And can you be more specific, counsel?
Did you take measures to protect anyone, including yourself and others?
Yes, I did.
What did you do?
Well, aside from what I've already testified to, namely warning people I thought were in danger, I also tried to arrange for my wife and family to be located somewhere where they would be out of the zone of danger. I tried to arrange for myself and for Ms. Smith to be out of the zone of danger. I took security precautions around
Out of the zone
our
of
house,
danger, meaning directly
having
with
the
him.
security system fixed. I added new security in the form of shatter detectors for the glass in the back of our residence, which we had not previously had installed. I bought, with my wife, 3 shotguns. In addition to that, we hired an armed guard response unit for our home, and several policemen. We called several policemen at some point and just asked them what general protections you could take. They had disclosed things such as, not having people follow behind you and tailgate you and so on and so forth. So I called up and found out what measures you could take if you thought that there was any danger involved with you. So I did that as well. And those are pretty much some of the precautions that I took, make sure I was out of town for some significant part of time when I thought that I was in danger, threatened. There were a lot of different, I called a number
Yeah.
of people and
DJ
asked them for
Drake,
advice. A lot
he
of
said
different
that
things that I did.
he was like
Now,
too
with respect to
concerned with the trauma
immediately
and
after
the
defendants
the
had
threat
left,
to take notes.
after the threats were made, and after you learned of the confession,
Make of that what you will.
you indicated that you called certain people, correct?
That's correct.
And one you indicated was a Dr. Lulow.
That's correct.
Yeah. Dr. Lulow is also a psychotherapist,
Yes, he is.
psychologist. And did you get certain advice from Dr. Lulow?
Yes, I did.
And had you known Dr. Lulow from previous contacts with Dr. Lulow?
Yes, I had.
When were those contacts that you had with him?
I think they were 1986. I can't remember exactly the date.
The defense in cross-examination asked you whether you had been on probation, and you indicated that you had, correct?
That's correct.
Was Dr. Lulow your supervisor for part of the time that you were on probation?
Yes, he was.
Now, would you describe for the jurors why it was that you were on probation?
Yes, I will. In approximately 1981, I believe, a patient that I was treating initially
was
had
all
the
BS.
funds to be in therapy and was paying my fee in full. At some point during the therapy, he lost his job and he no longer had any money to afford therapy. And I told him that I wouldn't charge him anything for the therapy since he couldn't afford to come in for therapy. And I continued to see him for some period of time, and he was quite significantly depressed in my clinical judgment. At some point in the therapy, as he became more depressed, he told me that he was uncomfortable not paying me anything for the therapy because he knew that my fee was a significant fee, and he had begun by paying me the fee, and it was not our original agreement that he not pay me a fee, and he felt obligated and uncomfortable and just like it was a big burden. At that point, I suggested that maybe he would want to be referred to another psychotherapist, which I thought would be appropriate if he was having those kinds of feelings. He said, no, he couldn't go through all of this again with someone else. He already had formed a close relationship with me and had already gone through all these things and reached a particular point, and he was too depressed. He just didn't have the energy to continue to start all over again with another therapist. And I told him I was quite concerned that if he didn't get therapy, potentially he could be suicidal, and that I was concerned for his welfare. And he suggested to me that the only way he would feel comfortable continuing to see me in therapy at all was if, in fact, I allowed him to do something, since he had no money, to feel like he was in some way paying something for the therapy that he was receiving. It was his suggestion that he do some handyman work around the house so that he would feel like he was at least paying something for his therapy. And I agreed that in order to have him continue in therapy and continue to receive treatment, I agreed to have him perform some handyman work around the house, which was, in terms of the value of the work, it was a tiny fraction of what my fee was. So there was definitely no attempt to exploit him at all. I was just trying to help him. But the bottom line is that he did perform some work. I was not supervising him or involved with the work. And at some point, he later saw another therapist who, upon hearing that took place, concluded that it was a technical infraction in relationship to the ethical code for psychologists, made a complaint with the board. I stipulated that, in fact, that was a technical violation with the board, although I made it quite clear that I was attempting to help the patient. It was because I feared that he might be suicidal or not receive any help if I didn't engage in that agreement. The board so stipulated that, in fact, I was trying to help the patient, not harm him, that it was a technical violation of the ethical code. And that is, in fact, that's the probation and that's the event. And that was, I guess, about 12 years ago. And that's the only.
Now, what period of probation was imposed?
I think there's a standard period of probation, which is 5 years for any, if you're ever put on probation, it's 5 years.
What period of time did that cover?
Well, let's see. The event occurred in 1981. I don't think that the probation occurred until 1985 or 6 or something like that. It took a very long time for them to.
Now, when did the probation end?
It ended, I don't know if it was last year or a year and a half ago. I don't recall when it ended, but it ended some time ago.
So during the period of time that you saw these defendants, October of 1988 through about February of 90, you were on probation.
I was on probation, yes.
Now, the defense asked you in cross-examination whether you disclosed your being on probation to all your patients during that period of time. Is there any requirement that you advise the patients that you're on probation?
Absolutely not.
Okay.
No requirement whatsoever to advise anybody that you're on probation.
Now, after talking to Dr. Lulow and getting advice from Dr. Lulow, you indicated that you had tried to reach your attorney, Brad Brunon, but you weren't sure whether or not you had contacted him. Is that correct?
That's correct.
At some point, you did contact him.
Yes, I did.
And do you recall approximately how much later, if not that night?
Could have been that night. Definitely would have been either that night or within a day, I would guess.
Did you disclose to your attorney that you had been threatened?
Yes, I did.
And did you disclose to your attorney that patients had confessed to murders to you?
Yes, I did.
Did Brad Brunon, your attorney, give you any advice on what to do at that point?
Yes, he gave me some elaborate advice.
What did he tell you?
Objection, yes.
Overruled.
Well, first he told me that he was scared to death by what I had just told him. He said he was really frightened. He told me that he was a criminal law attorney and
Objection, I'm going to object to this.
All right, the question was advice. What advice? was
what
given?
advice did he give me?
Move to strike the previous sentence.
That portion of the answer will be stricken. Let's start over again. The
Okay.
question was, what advice was given to you?
Thank you, Your Honor. The advice given to me was that he couldn't be sure what to advise me because he said the situation that I described seemed like a no-win situation and a no way to be safe situation.
Let me ask you this, Dr. Oziel.
Yes.
Did you give your attorney,
To strike that, it's not responsive to the question of what advice.
Overruled. The answer will stand.
Dr. Oziel, did you give your attorney, Mr. Brunon, some information, some particulars about the nature of the statements that were made to you?
Yes, I did.
What did you indicate to him?
Objection, hearsay.
Overruled.
I indicated to him that there were
At this point, we would assert the privilege. He has no right to give us.
Counsel, do you want to argue the matter?
Yes.
Okay, you may come up here and we can have a discussion. Or better than that, ladies and gentlemen, it's about 2 minutes to the hour, so let's let you get on your way for lunch and come back at 1:30. Don't discuss this case with anyone or form any final opinions about it. We'll see both juries back here at 1:30.
So I get why Leslie doesn't want the jury to hear this.
The jurors have now left, and the question had to do with what you told Mr. Brunon. Let me ask the witness, whatever it is that you told Mr. Brunon, was it in relationship to what had been told to you in the session of October 31st by the two defendants?
To the best of my recollection, Your Honor, I didn't identify the two.
I understand that, but whatever you told Mr. Brunon, did it relate to what had been told to you on October 31st?
In a general sense.
All right, you did not relate to Mr. Brunon contents of any sessions you had with the defendants prior to October 31st?
No.
Okay. And what is the defense objection?
The defense objection is that there was no court has previously ruled, and I don't believe this court has adequate information to rule that Dr. Oziel's disclosures to Mr. Brunon are somehow part of the dangerous patient exception or allowable under that. And so, and we're objecting to any information, to eliciting any information he may have given Mr. Brunon. That may have been a privileged relationship between him and Mr. Brunon.
Isn't an interesting bit on the privilege question.
Has by testifying, but we are not waiving the privilege. And short of the showing of necessity and that a person is within the potential for harm, the Supreme Court has ruled that the privilege is not waived.
Somehow your argument is that he can testify here in open court before the whole world about what he says your clients told him on October 31st, but he can't testify to what he told Mr. Brunon that day about that conversation.
The reason being, Your Honor, very simply, is that it's not at all clear from his testimony what our clients told him. Virtually every time he's called upon to testify about it, facts and details change. He has said the notes are not total, but there are other things. I don't know what those other things are. They simply emerge from time to time. And therefore, I don't know what he would be likely to say. It may contain information that has not yet been revealed before the world, but it certainly would be information that the Supreme Court was not in a position to rule on because this issue was never presented to them.
Well, it is this court's view that the entirety of the October 31st session has been resolved by the Supreme Court in a fashion that it is not privileged, and the witness, his disclosure here in court about the contents or his disclosure to others is not privileged, and this is an area that was dealt with extensively in cross-examination as to what this witness told others, whether it be Ms. Smith, Mr. Brunon, Dr. Lulow, or others. The first mention of Mr. Brunon, as I recall it, was in the cross-examination of August the 5th, your cross-examination of the witness, and reference to the fact that the witness told Mr. Brunon about the confession. So this is certainly an area of proper redirect examination, and I find this area is not covered by the patient-therapist privilege.
I would also like to articulate for the record.
He's just he's so done with her right now.
Eliciting from Dr. Oziel, Mr. Brunon's fear.
Okay.
But on the assumption
We're
that
gonna
Mr.
skip ahead.
Brianna knew that that was
This has been an interesting argument, but we're going to skip ahead back to the testimony. So so we can really get to the juice.
Dr. Oziel.
Let's see here.
Unless you say-
Okay, still going back and forth with argument. Is this people coming back in the courtroom, perhaps?
All right, remind you, you're still under oath, and you may
Okay.
continue your redirect examination, Mr.
Thank you, Your Honor. Dr. Oziel, I believe we're at the point where you were discussing what the brothers had told you to your attorney, Brad Brunon, on the night of October 31st, 1989. Recall that?
You say what the brothers had told me. I was relaying the conversation to Mr. Brunon. Is that what? Could you
Yes.
repeat the question?
Question is, what did you tell Brad Brunon when you called him after the session that you had with the defendants in this case on October 31st of 1989?
I believe that I told him that that I had a patient or patients who had committed a murder, that there had been a number of threats to me in the session, that I was, to the best of my knowledge, the only person who knew of the commission of the murder, and that the threats were related to the fact that now that I knew that there was basically no way that that the people who committed the murder could feel safe as long as I was alive, that was the thrust of what I felt was communicated to me. And I told him I felt I was imminently under threat of being killed, and I didn't know what to do in terms of options. And he then asked me, as I recall, whether there was other evidence that related to the commission of the crime. And I said no. As a matter of fact, the specific statements made to me is that there was no other evidence as to the commission of the crime. That I went through the information about there being no fingerprints. Well, the fingerprints being theirs, but they lived in the house. That the weapons were removed. There were no casings. No one apparently had heard anything. No one apparently had seen anything. And what was relayed to me is that at this particular point, with the exception of my knowledge of it, and also that the people were not under suspicion at all, with the exception of my knowledge of it, that there would be no evidence linking them. And he, I think, began discussing how that was a very scary scenario. That was very frightening.
Did you indicate to Mr. Brunon that the brothers had used false identification in the purchase of the shotguns?
Yeah, I don't remember if I relayed that information or if I didn't, but I did tell him that the weapons were not in evidence, and they probably weren't going to be found. And he just said that that's very frightening. And I said something like, I'm really trying to, I want to help them if I could help them and continue to act as a therapist. On the other hand, I'm really afraid that I and other people might be killed, and I'm not sure what to do. and so I'm coming to you for advice. And his response was that it was like almost an impossible situation. He said that if in fact I went to the police and turned them in, with his experience as a criminal law attorney, that based upon the evidence that I said was existent, that it was at best the flip of a coin whether they would ever be convicted. And he didn't even know how long they'd be held if in fact that there was no evidence other than my saying that they said this to me. And he said, with the people that you've described, if you turn them in and they get let out, he said, I'm certainly not willing to advise you to do that because there's an unacceptably high risk that you'll be killed. And he said, on the other hand, he said, if you try to continue treating them, he said, I can't warrant that you won't be killed either. And he said, in addition to that, he said, I can't even suggest to you that you join or become a part of the witness protection program. And the reason for that is, he said, the witness protection program is something where you have a whole new identity, and maybe you'd move to another city, no one would know who you were, where you were. He said, it's just not something that's even viable. It's not even something you could do. You have a lot of ties to this community. You're professional in the community, so on and so forth. I mean, it's just not viable at all. And he said, on top of all that, a lot of people in the witness protection program get killed. He says it's a little known fact that many people in the witness protection program, in fact, are killed. So he said, I don't really know what to advise you. Really, what I need to tell you is that, I don't see a real good choice. I don't see a real good set of options for you under these circumstances. He said, I'm not comfortable under the circumstances advising you to do one thing or another. You have to use your best judgment.
So let me pause real quick right here because we've got some questions here that are kind of repeating here. We've got Gamer Ducko, isn't this hearsay? Secret. Oh, sorry, not that was the wrong one. Kit Kat, I don't understand all the hearsay being allowed in. But thank you, Secret Mix Girl, for for putting the links out there. So this question of hearsay. Remember that whenever we're talking about testimony where the witness is saying so-and-so said X, so-and-so said Y. The definition of hearsay is not just the fact that an out-of-court statement was made by someone, but that it's being offered to prove the truth of the matter asserted. So you have to ask at every time, in order for it to be hearsay, you have to ask, what is this being offered for? And the purpose of him relaying all of these conversations that he's had, one was with, that prior client that he was on probation for. And now this one is his conversation with his own attorney. The purpose of asking for him to go through that conversation is to get the impression of the impression that conversation left on him. So we don't really care so much about whether or not his attorney was being truthful or honest in what he was saying. Same thing with that other client that, led to him being put on probation. But really what we're more concerned with is like what that person said, if that, made an impression on him and if that somehow impacted his decisions or his actions. So that's why these are being allowed in right now. And there could be other purposes for that testimony to come in as well. But that's the thing that jumps out to me is that really what we're trying to get at is what impacted his decision making for the, what he decided to do. Having a conversation with a criminal law or with an attorney who has a background in criminal law, like that can influence someone to be like, oh, I really should be worrying about, about what these guys are saying and doing. If this guy seems to be worried and he deals with people that have done bad things plenty of times, So anyway, so that's basically that. So I know there were a lot of questions on hearsay, and that's why all of that's being allowed in, really without any kind of objections. And you know that Leslie's going to object at every opportunity because she's doing it. And part of it, I think, is just to interrupt the flow. She's being pretty successful at it. Even though she's not winning on all of her objections, she is interrupting that flow. And, that can interrupt the attention of the jury, perhaps, possibly. Sometimes that's not always successful. Sometimes you interrupt too much and the jury just gets to be annoyed with all those objections. And they're like, come on, like, let me listen in on what's going on here. So anyway, so it's interesting that she hasn't been objecting for any of these other guys. And also, Andy the Game Maker, thanks so much for not only being here, but also for gifting 5 Legalbytes memberships. So to all the folks that are now members of Bite Club, I see Anna Costello, Diana, Haley Mouse, Senbo, Stephen McCormick. You guys have all been gifted memberships. So to all of you guys, welcome to Bite Club. And Andy, thank you so much. You are such a wonderful, supportive big brother. So thank you. And good morning to you. So yeah, okay, let's continue.
You had to make a lot of quick decisions that night, I take it.
Yes, I would say so. I would say that within about 10 minutes, I had to make all the things that we're talking about or have been talking about over all this time. I really just had from the end of the session to 10 or 15 minutes afterwards to try to assimilate everything that had happened and to try to make decisions about what to do to try and act to protect people who were potentially going to be harmed, and also to try to protect my patients and not go to the police if, in fact, there was a way to try to lessen the threat such that I didn't have to go to the police.
Do you know where Brad Brunon's office was on October 31st, 1989?
To the best of my belief, it was in Santa Monica, but I don't recall he's moved 1 or 2 times.
Now, do you recall the exact sequence of the calls? You indicated that a call was made to Dr. Lulow, a call was made to your attorney, Brad Brunon. You also indicated in cross-examination, I believe, that you called your wife.
That's correct.
Do you remember the sequence of the calls?
No, I really don't remember the sequence.
With respect to the call to your wife, you indicated when counsel for the defense brought up some phone records that there appeared not to have been a notation or a record of a call from your office to your home at that time, I believe, if I'm right, is Sherman Oaks?
That's correct.
You indicated, or is that a toll call from your business phone?
No, it is not a toll call, to the best of my knowledge.
In fact, you checked the records that were presented to you by defense counsel, and you reviewed those records, and there wasn't one call to your residence. Is that correct?
No, there wasn't, despite the fact that I called my residence from my office, anywhere from several times a day to 20 times a day.
Okay, so Beverly Hills to Sherman Oaks.
That's correct.
Now, at some point, you did reach your wife, correct?
That's correct.
And you told her to leave the house with your children?
I did.
And sometime later, you went to your girlfriend's house, Julian Smith.
That's correct.
Still don't
Would you
understand the
describe
logic in that.
What you did after making the calls that you made that night, and describe for the jurors what you did when you exited your office.
Well, when I exited the office, best of my recollection, I think I went down and asked for a security guard to escort me to my car, as I recall. And then what I did is, after I got in the car, I backed out and drove around and saw whether, in fact, the Jeep was still there, parked there. And it was not parked there. And at that point, I recall having driven to Julian Smith's house.
As you were driving, did you ever check in your rearview mirror to see if they were following you or anything like that?
The best of my recollection, I did a couple of times check in my rearview mirror. I pretty much had the belief at that moment that they were not following me to her house.
About how far was Julian Smith's residence from where you were in Beverly Hills?
Only about 10 minutes.
Now, that night when you got to Julian Smith's home, did you then warn her about what the brothers had told you and how they had threatened you?
Yes, actually, I disclosed.
I'm going to object to Mr. Lord
Objection overruled. The
Yeah,
answer is yes. Your next question.
yes.
And what warning did you give to Judalon Smith, if you recall?
The best of my recollection, since she had no knowledge at all about the situation, I described the situation of two patients of mine having murdered their parents, and that I felt that I was imminently at risk, and I also thought that she was at risk, and that my wife and children were at risk, and that I thought that they, if they hadn't followed me, that they could detect our relationship. And I, offered to her at that time and suggested at that time that maybe she would want to be apart from me, or that, if she felt safer, she could choose to be with me, whatever she wanted to do. I also told her some of the details of the sequencing, and including the fact that Erik had come in first, that Lyle had come in second. Told her that afterwards I had made some calls to police and to Dr. Lulow, so on and so forth, and that I then had gone down and gotten escorted to the car, and that that's what had happened. And I told her something about the nature of the kind of issues that involved the commission of the murder to begin with, and I also characterized something about how dangerous I thought the clients or my patients might be, and the nature of the crime that was committed, so that she'd be able to accurately assess the amount of danger that she was in order to be able to protect herself and know what kind of action she needed to take.
Now, in cross-examination, you testified that you believe that the defendants could come to your house because you indicated that Erik Menendez knew where you lived, correct?
That's correct.
After you had asked your wife and children to leave your house, you indicated that there was a chance of the defendants breaking into your house. Is that correct?
I was very concerned, because they knew where I lived, that they might break into my house that night, number one, to attempt to kill me, and number two, to try to look for any information that related to any other people who might have access to information about them. So for both reasons, I was concerned about them breaking into my house.
And you had indicated that there were some records of business transactions or potential transactions that you would have with Judalon Smith in your home. Some plans.
That's correct.
Judalon Smith had some kind of a sound and light business. Is that correct?
Yes, she did.
And when is it that she first contacted you?
I think it was in June of 1989.
And was it a business offer that she related to you in that first conversation that you had with her?
Well, I'm gonna object to the
Objection is sustained.
What was your first contact with Judalon Smith?
The first contact with Judalon Smith was simply her calling and asking me about whether I had any tapes. She mentioned something about a tape called Through the Briar Patch or something, and asked whether I had any tapes in relationship to phobias, that she was planning to put out a line of tape recordings on psychological topics, educational things of that nature. And she was particularly interested in phobias and the treatment of phobias. And I told her I didn't know anything about that tape, hadn't heard of it. And then she asked me whether that was my specialty. And I said, yes, it was. And she said, well, have you ever done any teaching or lecturing or anything that would give you any authority in that field to do some tapes in that area? And I said, yes. So she basically proposed that we, number one, ought to get together to talk about the possibility of doing a line of tapes, with her being the person who did all the tape production and duplication and marketing, and me being the person who put the tapes together. At the same time, she also suggested that and told me that she was in the tape duplication business, and that in the event I ever needed any tapes duplicated, she asked me if that could come up. I said yes. Didn't come up often, but it could come up. That she was in that business, and she also worked with strict confidentiality. She said that she had worked for the FBI, and I believe she said the DA's office before, dealing with highly sensitive material, and that she was used to dealing with very confidential material, and she could be relied on to keep it. And then she said she was going to send me a tape or book. I'm not sure what she said the next couple of days. And she wanted to get my reaction after I listened to it. And could I call her back and let her know what my reaction was?
Okay, before we get to that, you had testified that you don't recall Judalon Smith being at your office on October 31st, 1989. Is that correct?
That's correct.
But you testified that you remember her being at your office on November 2nd, 1989.
Yes, she did come against my instructions to her.
So this November 2nd, 1989 was after you had warned her about the danger of the defendants.
Yes. At some point, she brought a gun in, I think. I don't know when that was.
Now, are you aware that Judalon Smith claims to have
Can't wait
actually
to hear
heard the
from
brothers
her.
confess and threaten to kill you?
Objection, Your Honor, it's hearsay.
Are you offering this for the truth?
No.
Objection overruled.
I'm
As
aware.
far as the question is concerned, are you aware of that?
Yes, apologize, Your Honor. Yes, I am aware of it.
Do you know whether on November 2nd, 1989, whether she actually heard anything that the brothers said that day to you?
No, I don't. It would be the best of my belief that unless something very unusual happened that she couldn't have heard, because from the waiting room, I don't believe it's possible to hear anything that someone's saying in my inner consultation office. But I don't, the answer is, I don't know. I can't be certain.
Okay. Now, you indicated that Judalon Smith called you about her tape duplication business and offered some of her services in that regard.
That's correct.
Did she mention to you any other people that were involved in these kinds of tapes, kind of self-help tapes?
Yes, she talked about neurolinguistic programming and I guess, I think she mentioned Tony Robbins and.
Now, Tony Robbins is the guy that's on TV with Fran
Your Honor, I'm
Tarkenton.
gonna object to this as irrelevant.
Overruled.
Man, how long has Tony
Is it your
Robbins been
understanding
around?
that this Tony Robbins, who's on TV and he pushes his tapes, is always on TV with Fran Tarkenton? Is that the person that you understood her to be talking about?
I don't know anything about Fran Tarkenton except that he played football, but yes, I know who Tony Robbins is. I mean, I know him from TV.
So she wanted to get into this business relationship with you.
That's correct.
And in fact, according to your CV, you have written textbooks in your field, or a textbook in your field, psychology.
That's correct. I have written a textbook.
And you've written articles in psychology.
Yes, I have.
Well, I'm
Just
objecting
because
to
it seems like it, right? I mean, apparently.
Objection overruled.
Now,
Like he was
Dr.
well known
Oziel,
in the late 80s already, I
the
guess.
defense in cross-examination has asked you whether you were obsessed with Judalon Smith, and you stated that you were not obsessed with her, but rather she was obsessed with you. Is that correct?
That is correct.
Now, you indicated that you met Judalon Smith first. The first contact was that she had contacted you about this business relationship or potential business relationship. Is that right?
That's correct.
And sometime after this June 1989 initial contact with you, did she send you a letter?
Yes, she did.
Your Honor, I have a 14-page collection of documents stapled. They have them marked as Exhibit 120.
14 pages of documents. Okay.
Exhibit 120.
Is this going to be some kind of letters of her
Can I
like
approach the witness?
professing her love for him or something? That's probably what we're about to. See here?
It's been marked as Exhibit 120. Take a look at the first page. Do you recognize what's on that page, sir?
Yes, I do.
And what is it?
Well, it's a business solicitation letter asking me to.
Your Honor, I'd object to the witness characterizing it. You can read the letter.
Well, objection is sustained in that it goes beyond the question. The answer is non-responsive. The witness said, yes, he is acquainted with the letter.
And do you recall receiving this letter, Dr. Oziel?
Yes, I do.
And do you recognize the writing, the handwritten message on the first page?
Yes, I do.
Whose writing is that?
It's belongs to Judalon Smith.
It appears to be dated June 15th,
All right. What's it
1989,
going to
That's
say?
correct.
with Judalon Smith's business card.
I'm
correct.
expecting.
Would
I'm
you read for the
expecting
jury
some
what it says?
very
Yes,
passionate
it
words.
says, hi, Jerry. Thank you for your time and consideration. Enclosed is my poetry book as a token. If you don't have your own tape line, you should. And since that is my business, perhaps I could be of some help to you or the center. So please file my business card for future use. Thanks again. All my
it's
best.
very
Jude Lyle.
professional. That doesn't sound obsessive. Is there going to be
Going to
another
the-
letter?
Next page.
Okay, let's go to the next one. Are we going to see
Is
a
the date of that
progression
page
from
August
professional
11th,
romantic?
1989?
Yes, it is.
Because so far that first one was
And you recognize
underwhelming.
the writing on that document.
Yes, I do.
And who is that document from?
Judelon Smith.
Now, is that letter, in that letter, does that indicate to you her feelings about you?
Yes, it does.
In which she says, you feel
Okay.
so good, and thanking you for not running in the other direction. Is that correct?
That's correct.
Okay, and going to the next letter within this exhibit.
So a very
You
small
recognize the
snippet of
writing
that
on
letter,
that
though.
letter.
Yes, I do.
And whose writing is that?
It's Judelon Smith's.
Now, there appears to be a date, 989. Who placed that date there?
I did.
And when did you place that date there?
I don't recall. I think it was just logging the, so I took these out of envelopes, just logging the time that they came in. But I don't recall the exact time I put the date there.
All the other writing is Judelon Smith's writing?
It is.
I mean, for someone who says that she's the one that's obsessive, it's interesting that he wants to document the date that they came in. I'm sorry. Granted, I'm going into this a little bit skeptical of what the prosecution is gonna, show up here, but maybe it'll change my mind. But the little bit of like, no, I'm not the one that's obsessive. She's the one that's obsessive. But he's like, trying to play it like, I'm trying to keep her at arm's length, but also go over to her house when I'm in danger and she's also in danger, and I'm not placing her in danger, but I, it is strange. Like, I can say that from personal experience, when you are seeing a guy that is interested, when you're seeing a guy that isn't interested, there is a difference. The guy that's not interested is generally not going to be writing the dates of the letters that you send to him. Probably won't even be keeping them in the first place. But certainly wouldn't be writing down the date to like commemorate when those letters came in. That's just me. That's just my personal bullshit meter here. Oh, man.
And you first met Judelon Smith in June of 1989?
That's correct.
Care Bear, that's
Now, with
fascinating.
respect to this page,
Maybe we'll get to that
is
poem.
does this letter indicate to you her sentiments about you? In particular, the seed of our love was there long before we met. It's part of life's plan, destiny. I, for one, have been saving up a lot of water, lots of food, lots of love, and I want to nurture this to full bloom. Is that her sentiments to you in that letter?
Yes, it is.
And with respect to the next letter, also dated 1089, and is that also your date up
Yes,
at the upper
that-
right-hand corner?
That's correct. I wrote that.
And does Judelon Smith, and do you recognize the writing again?
Yes, I do.
Is that Judelon Smith's writing?
It is.
And does this letter indicate to you that she wants to give you hugs in person rather than phone hugs? She wanted to come to the office to give you hugs, but you didn't want her to. She talks of business things, and she wished you could just come home to her every night and make the magic happen when you're together. Is that right?
That's correct.
Are these some of the indications to you that she felt obsessed with you as you testified?
Among many others, yes.
Okay, is this just a sampling of the letters that you received from Judelon Smith?
It's a very small sampling, yes.
Okay.
That to me
The
doesn't
next
read
page,
like obsession.
Also dated 1089.
That's
Is
a
that
woman
your
that's
date?
Yes, it is.
like
Uh,
in love.
Is that a letter which indicates dearest Jerry, wherein Judelon Smith expresses her desire not to place limits on the relationship? She just wants to love you to the fullest each day and be loved by you. And quote, why do you push my panic button by saying things that are limit oriented? I'm trying not to drive you crazy. I love you. Do you know how wonderful and thoughtful and fun and loving and special you are? Do you remember getting that letter from Judelon Smith?
Yes, I do.
And with respect to the next letter, dated Monday, October 16th, 1989, it's a 3-page letter.
Yes.
Actually, I'm sorry, a 2-page letter.
2-page letter, yes.
Do you remember seeing this letter
Yes,
on or about October 16th?
yes, I saw it in person.
And with respect to all the writing on this 2-page letter, is that Judelon Smith's writing,
It is.
except for the upper left-hand corner, which I believe you characterized the note?
Yes, that's true. I wrote those 2 words and the box around them.
And it says suicide note,
It does.
in which Judelon Smith leaves you her 2 kitties. Is that right?
I think she requested that I took care of her 2 cats.
Do you know the names of her cats?
Well, they're listed in the letter here.
Did you know before that, though?
Probably at one point I did, but I'd forgotten.
Shanty and Ishi Kitty?
I believe that's correct.
Okay. Now, the next letter appears to be November of 89. And
Can we
Here's-
get clarification as to whether he's writing the date on this letter?
On which
I'll ask
one?
him that.
The October 89 or
Yes.
Oh, I'm sorry.
October the 16th, 1989, is that the one?
November 8th.
Oh, okay.
Okay. With respect to the Monday, October 16th, I believe that is her date. Is that correct, Dr. Oziel?
That's correct.
Okay. Now, the next letter appears to be dated 1187 in the upper right-hand corner. Is that your date on the letter?
1187 or 1189?
I'm sorry, 1189.
That's my writing.
Okay. And this is a 3-page letter.
Looks to be, yes.
And did you receive this from Judelon
I don't-
Smith in November of 1989?
I did.
And is this her writing in this letter?
Yes, it is.
And basically, in this letter, does it say, "You are the kiss of life. I love you. I love being near you. Your love pulsates through me, unlocking doors to rooms no one has ever gone. This is timeless love that occurs and reoccurs from lifetime to lifetime." Was that her sentiments in November?
That's what's contained in the letter, right? Yes.
She writes other letters that contain the same sentiments.
Yeah, these are
Later
romantic.
in November,
They're definitely getting romantic.
November 25th, 1989, is that correct?
That's correct.
And without going through all of this, the next 2 letters after November 25th, 1989 are a Valentine's card, February 90. Now, with the exception of the 290 in the upper right-hand corner, is all the writing Judelon Smith's on that Valentine's card.
It is.
And
So
I'm not going to
Katoa,
get into the
I'm
substance
still
of the
convinced
last,
that he's
2
the one that's
pages that
obsessed here.
comprise the last letter.
Even
But,
with all
you
of
have
this
a date, I
flowery
believe, of
language.
290 in the upper right-hand corner. Is that your
Sounds
writing?
like
That's my writing.
Everything
love.
else is that the printing rather than the
I want to know the
handwriting of
age
Judelon
difference
Smith.
too between them.
Are we on the Valentine's Day
She's a bit
letter?
younger.
No, this is the one right
I'm
after the Valentine's
Oh, I'm
Day.
sorry.
That
Yes,
can
that's
also
true.
be
That's the printing of.
an
Judelon Smith.
indication here.
Okay, and just basically that last letter indicates, "It makes me sad that I sabotaged the most important, loving, giving, caring, and passionate relationship I've ever known. You're a very generous person to call me 14 hours after I've been a total asshole and tell me good things about me, and you believe in me. I hope I don't let that belief down. I want to make you happy. Love and zillions of kisses, Judelon." Was that another letter that you received from Judelon Smith?
Yes, it is.
Well, sometime after February of 1990, you broke up with Miss Judelon Smith. Is that correct?
Well, I've been trying to break up with her all along, but yes, the final incident was.
That's why I invited her to live with
sometime
me and my
immediately
wife and
afterwards.
kids.
Are the letters that you've just related, among other letters that apparently you have received, are those some of the reasons why you testified in this court that when asked by the defense whether you were the one that was obsessed with Judelon Smith, that you said, "No, she was obsessed with me"? Is that why you said that?
Objection sustained.
Okay, why is it that you testified that you were not obsessed with her, but rather she was obsessed with you?
Well, these letters and the multitudes of other letters that I have in my possession that she sent me, some of which are a lot more extreme than these letters, are only a small part of the whole picture. She also, in person and in phone conversation was very continuously trying to push and move the relationship towards something that I told her in the very beginning that it couldn't be and that I didn't want it to be, which is the reason she talked about why are you always limit setting and why don't you stop making, I'm trying not to drive you crazy. Why do you keep mentioning limits? Just let's take things day by day. It's because I was repeatedly telling her that that I didn't want to be in the relationship anymore. And I thought she was getting much too intense and that she was misunderstanding what was happening in the relationship. And I felt I needed to leave the relationship. Each time I told her that, she threatened suicide. And then the one time, the October letter, she actually, I don't know if she set things up or what, but she actually asked me over for a final meeting to give me back the business materials. And when I came in, there was a suicide attempt in progress. So pretty much continued, and that was only several weeks.
I don't know that I'm buying
several weeks
this.
before the 1031 session that Judalon Smith had made the suicide attempt. So I was pretty much after the first couple of months telling Judalon Smith that I needed not to be in this relationship, that it was an error, and that she was not taking it at all in the way that I'd intended it for it to be, and there were limits on it. And in addition to that,
hang on. I'm pausing because I was literally about to say curiouser and curiouser. I was literally about to say, I find it weird that they are not reading the really obsessive letters, the, quote unquote obsessive letters not being read out loud, just summarized. I was exactly going to say that is something that is very suspicious to me in watching this testimony. And I'm sure the jury is thinking the same thing. It's like they'll read tiny little snippets of it, or they'll just summarize it entirely. So there could be so much context to these letters that is getting lost in the summary. And I'm wondering if on recross, you we're going to see somebody like Leslie Abramson is going to get up and be like, I'm sorry, this letter says all of this, and you're saying that that's obsessive? Like, okay, let's get into the context. Or maybe these letters are going to be brought up during Judalon Smith's testimony, so that they can ask her, like, what did you mean by this? What did you mean by that? Were there other conversations that happened around this that can help to sort of, illustrate all of these other things? Yeah, it is very suspicious that they are just summarizing these and kind of trying to go kind of quickly through them and be like, yeah. She's the one that's obsessed, right? Oh, yeah. Of course. KWNY Upstate. Thanks so much for the super chat. He sounds like a psychological professional that understands emotions clinically, but has no real understanding of love. Yes. That is like bullseye. That's my impression as well. But yeah, these letters, man, I want to see these letters published for the jury, right? Like put them up on the screen so that we can all see what these letters look like. Do they really stand up for what the prosecution says that they do? Because right now I don't feel like they do based on the way that they're presenting them.
I just felt that the nature of what she was writing in not only these letters, but in many other letters, and the nature of what she was saying, she was frequently trying to press me to not be in my marriage and to be with her. And I was repeatedly telling her that wasn't at all what this was about, so on and so forth. And I just, that's the entirety of that is the reason that I
Just because,
felt
thank
that
you
she
so much
was,
for gifting 5 Legalbytes memberships.
fixated on me.
Sorry. Fizzy water went down the wrong
Didn't
way.
tolerate me breaking up with her.
Thank you so much. It's so
Did
kind and
Judalon
so
Smith
generous
know
of
that
you.
you were married at the time?
And to all the folks that
Oh,
are members of
absolutely. She
Bike
knew
Club,
from,
welcome to Bike
from the very
Club.
beginning that I
Hope
was
you can make it
married.
on Friday.
And did your wife
To our members
Laurel
only
know
live
about
stream.
Judalon?
At some point, yes, she did know about Judalon.
And at some point, because of the danger, she actually came to live with you and your wife. Is that correct?
Because of the danger, because Judalon Smith.
Because I definitely wasn't obsessed with her.
Stated, number one, she was making some threats.
I'm going to object that the answer is not responsive.
Objection sustained after yes. Everything else is stricken.
All right.
Now, at some point, do you recall when you actually broke off the relationship with Judalon Smith?
Yes, I do.
When was that?
Well, sometime in early March.
Do you recall having a tape played in which you made calls to her house?
Are you referring to the tape that Mr. Burt played that he was using as, I believe, as evidence that I was obsessed with her or something of that nature?
Yes,
those tapes?
that
Yes. Uh-huh.
evidence. You actually
Yeah,
made
but
calls
don't
to
say
her
that
residence,
you
is
were
that
obsessed
correct?
with her. Don't use those words.
Yes, I
That's
did
what the
make calls to
prosecution's
residents
thinking.
for a specific reason.
What was that?
Well, the reason was I had just basically told her to get out of the house, and knowing her history of having been either suicidal or histrionic, I was concerned. Number one, I was concerned she was going to go to the police, and I was concerned she'd put herself and my family in danger. So that's one concern I had. And the second concern I had was that she might kill herself, and neither one of those was something that I was comfortable with. And so that series of calls that Mr. Burt played were really just completely not representative of what happened in terms of my calling Judelon Smith at all. They were simply my calling her at that one moment in time when I was concerned she was either going to go to the police or that she was going to commit suicide. And she had left her car outside with her clothing underneath the car in a bag. And that looked very odd indeed. And I was concerned that similar to something she'd done before, that maybe she was inside and she was attempting to commit suicide or something. That's the reason I made those calls.
Now, when you said that you're afraid that she might take the information to the police, were you still operating under the advice given to you by Brad Brunon back in October of 1989 that just with what you had, it was 50-50 as to whether these defendants would be convicted? Were you going on that advice?
Yes, I was. I still did not know anything about there being any other evidence whatsoever in this matter.
And did you feel at that time that if the police were notified and the brothers became aware that you turned over the tapes, that you would be in danger?
Yes, I did. And yes, I did. I'm sorry.
Now, as you've testified, Judelon Smith contacted you to offer her services as an audio tape duplicator. In fact, did she duplicate the tapes of the Menendez brothers that were ultimately found in your safety deposit box when the Beverly Hills Police Department served a search warrant on your home and offices on March 8th, 1990?
She did.
She duplicated those tapes.
She did duplicate those tapes in my presence.
Now, focusing back on the defendants in this case, you have indicated that you've made the warnings that you made to your wife and family and to Judelon Smith, and you've told Dr. Lulow and your attorney Brad Brunon about what information you had. What do you think you accomplished by telling the defendants that you had notes of the sessions with them and that your attorney was instructed to go to the authorities with the notes or tapes if you were to be killed or murdered or mysteriously disappear? What did you think you accomplished by that?
I object to the floor to that question.
Sustained.
Okay. What did you think that you had protected yourself in any fashion?
Objection.
What time frame are you talking about?
After you recorded your notes, your audio notes of the sessions with the brothers, and you informed them that you had the notes, what do you think you did to protect yourself?
Objection.
Also mistakes there.
Objection sustained.
Dr. Oziel, why don't you explain to the jurors what you did to protect yourself in getting the tapes that you made or making the tapes of the notes?
Now I'm going to object and ask you a question.
All right.
Thank you, Your Honor. Dr. Oziel, why did you make those tapes? October 31st and November 2nd.
And to lay some foundation here.
I made the tapes as a way of, I made the tapes for a different reason. I'm sorry.
Your Honor, perhaps you should ask a different question.
All right. Why were these tapes recorded by him? You're talking about the tape of October 31st and November 2nd, why he recorded them or
Yes.
why he had them duplicated?
Well, I'll do the recorded first, and then I'll get to the second step.
Okay. Now we're talking about October 31st and November the 2nd.
Could you repeat the question?
Why did you record your notes from the October 31st and November 2nd sessions?
For a variety of reasons. Number one, it was important for me to preserve as much detail as was possible to document what had transpired in both of those sessions for therapeutic purposes. It was also very important for me to record what transpired for the purposes of documenting what actions I took from a standpoint of professional responsibility. And third, it was important for me to document what happened and to get the documentation of that into a safe place as a part of a protection or a perceived protection that if in fact there was a follow through in relationship to murdering me, that the entirety of the details of those two sessions would be revealed as a way of trying to disincentive either Lyle or Erik from killing me.
In fact, the police served a search warrant on your house on March 8th, 1990. Is that correct?
That's correct.
And were you home at the time that the police served the warrant?
I was not.
Did you get a call from your wife?
I don't recall if I called her or she called me, but we were in contact with each other while I was in the car.
And at some point, did you return to your home and find the Beverly Hills police detectives there?
Yes, I found a number of people there, including Beverly Hills police detectives.
And did you then call your attorney, Brad Brunon?
I did.
At that time, when you saw the police at your house, what was your state of mind with respect to the defendants?
Objection, well,
I feel like you can answer that.
Could you be more specific as to what you're referring to? Objection sustained.
With respect to the threat, your perceived threat, and the danger that the defendants posed, what was your state of mind on March 8th, 1990?
I believe that the defendants posed a threat. I was concerned about the fact that these notes were being seized, and I was concerned that if they learned that they were being seized, that they might think that I had simply turned them over or betrayed them to the police.
That doesn't make
which
sense to
in fact
me.
was not at all what happened.
That doesn't make sense to me because if he's concerned about them wanting to kill him because he has information, as soon as that information is out, why would they kill him? Right? Because if their motivation seemingly would be to prevent that information from going out, so killing him afterwards would have no impact on that. So I don't, this part right here, it doesn't fit for me.
Did you make any requests of any of the officers there serving the warrant regarding protection?
I believe I did ask for some sort of protection.
What sort of protection did you ask for?
objection, no.
Overall,
I
it's
think I
relevant.
asked for some police protection.
Was Brad Brunon there at that time?
He was.
Now, at some point, did you or Laurel, your wife, accompany the detectives to the safety deposit box in which these tapes were located?
Both my wife and I accompanied the detectives to the safety deposit box location.
And was there a special master, Gary Mogul, there?
There was.
Do you remember whether Detective Zoller was there?
Detective Zoller was there.
Do you recall actually who recovered the actual tapes from the safety deposit box?
My wife did with Mr. Mogul.
After the special master, Gary Mogul, took possession of the tapes, did you become involved in a closed hearing in Santa Monica Superior Court regarding the tapes?
Yes, I did.
Now, there's been a lot of reference to proceedings that occurred in Santa Monica in June and July of 1990. Were you involved and were you a witness in some of those proceedings during that period of time?
I was.
Now, was the privilege issue being litigated in Superior Court at that time?
Objection,
overruled.
At my instigation, I instructed my attorney, Brad Brunon, to litigate the privilege issue, which was not something I was obligated to do.
Objection, move to strike the answer as non-responsive.
All right, the answer will remain except for the last portion regarding whether he was obligated to do that. That portion is stricken as non-responsive.
Dr. Oziel, you were involved in this litigation, is that fair to say?
That's fair to say.
For the next 2.5 years, did the litigation include the Appellate Court of California, Second District, and also the Supreme Court?
Yes, it did.
Objection.
All right, the objection is sustained. The answer is stricken. Do you want to approach?
Yes.
Okay.
Dr. Oziel, when is it the first time that you spoke to the prosecution in this case about what the defendants had told you? Do you recall?
It was very recent. It was just before my anticipated testimony.
In the grand jury?
Correct.
Do you recall that as being in December of 1992?
I don't recall when it was, but
And getting back to the statements of the defendants on October 31st, 1989, in cross-examination, you were asked whether either of the defendants had used the word perfect in describing the murders. Do you recall that?
All right, with the understanding that you're not quoting verbatim, the objection is overruled.
Thank you, Your Honor. Do you recall that?
can you
Oziel?
repeat the question, please?
Yes, in cross-examination, do you recall a question being posed whether the brothers on October 31st used the word perfect murder or perfect crime?
Yes, they did.
Have you had an opportunity to review your notes?
Well, I certainly have, on the witness stand many times, reviewed my notes.
And do you recall now, after a review of your notes, whether or not, in fact, they had referred to the perfect crime during that October 31st session?
No, I'm going to object to the word they.
Objection overruled.
Yes, the word perfect murder was, the phrase perfect murder was used during that session.
I mean, but how do you really know? Because you didn't take notes during the session. You took notes like weeks later. So, yeah.
In cross-examination, you also testified that at one point, Erik Menendez believed or was frightened that they may get caught on that night. Is that correct?
That is correct.
Is that inconsistent with the language of the perfect crime?
No, and I'm going to object to that calling for conclusion.
Sustained.
Could you describe for the jurors how that information came up from Erik Menendez regarding the situation where he had left some cartridges in the car?
Yes. Prior to the actual commission of the murder, there had been a belief that that the brothers had formed a perfect crime, a plan that would not allow for detection. In the actual commission of the crime, both brothers realized that they had not committed a perfect crime in the sense that the way that it was executed involved leaving cartridges in the car. And since the police could easily have found the cartridges, that clearly was an error. And at the moment that that error occurred, it was no longer in the actual enactment a perfect crime. Once they created a reason for going back out to the car, I believe to retrieve tennis garb or tennis gear or something of that nature, and they were allowed to pick up the cartridges. Erik told me that they again felt that they had now a perfect murder, because to his knowledge that was the only way that he could have been caught that night, best my recollection. And then later, Lyle in the session related to the fact that Erik disclosed to me or confessed to me all of the details of the crime as now returning their situation to one where it was no longer a perfect murder, and the element of it being no longer perfect was the fact that I had a complete confession and had all the information, and at any time, insofar as Lyle was concerned, I could disclose it to anyone, and he related that he did not feel safe at all with that, and that there was no way he could feel safe with that. Even many years from now, I could relate that to somebody else or tip somebody or whatever. And so now I was what was making the murder imperfect, and he was basically alluding to how it was an extremely big problem. And the message I was getting is that he was considering what to do to remove me as a factor, so I no longer could ruin what otherwise would have been a perfect murder.
You're right, but I don't think all of that was responsive. Exactly.
Well, I'm sure you can go back and pick it up. Okay, objection is overruled.
Dr. Oziel, after you.
She's like,
established
I'm
this
ready for
relationship
recross.
With the defendants, that they knew that you had these tapes in the safety deposit box, and you had this, and you continued to see them after that. Is that correct?
Yes, I did.
And the sessions up to October 31st are still privileged, correct?
Yes, they are.
Objection, Your Honor.
Sessions after.
Excuse me, counsel. Objection, Your Honor.
Can I have the question read back, please?
Jeez. Man, she is dramatic.
Up to October 31st are still privileged, correct?
All right, there's an objection.
Yes, sir.
Okay, the objection is sustained. The
Now,
answer is
after-
stricken.
I mean, she was right.
After you established this relationship, that you had told the defendants that you had these tapes in your safety deposit box, was there ever a request on either October 31st or November 2nd by either of the brothers in the other brother's presence for you to put down everything and reflect everything in your notes that would somehow explain their motivation for killing their father?
Yes, Lyle in particular had expressed a desire to record or memorialize all of the factors that were motivation related that had to do with the commission of the murder.
And you've reflected those, or you've related those to the jurors based on your notes, those two sessions?
Objection, Megan.
Overruled.
Yes, based upon my notes and my recollection of those two meetings, I have fundamentally communicated the motivation as it was communicated to me.
Comprised of 5 pages. Gun records, may I have this marked as exhibit 121, I think?
121. Yes.
Can you tell me NY Upstate, why are they telling this to the doctor? You're
Dr. Oziel,
referring to
can you tell me
the
what's been marked
the
as
defendants?
exhibit
Why did they say
121?
that?
Do you recognize those documents here?
they were in therapy.
Yes, the top document.
They're
and,
being very honest about their
there's
feelings,
other
I
documents
guess.
as well. So I'm looking through them. Yes.
Assuming he's telling the
Do
truth,
those
of course.
appear to be the gun records reflecting your purchase of 3 shotguns on November 6, 1989?
They do.
Was your wife Laurel Oziel with you on that date?
Yes, she was.
Now, looking at the first page of this 5-page document, is that your writing?
No, that's not my writing.
Okay, but it indicates Leon Jerome Oziel as a purchaser.
That's correct.
Is that your signature in the middle section?
That is my signature.
Okay, and with respect to the driver's license, is that your driver's license number?
That is my driver's license number.
And with respect to the Sherman Oaks address, is that your correct address?
That was my correct address at the time.
You moved recently. you
That's
indicated.
true.
Now, you bought the shotgun at the Big 5 Sporting Goods shop, is that correct?
Yes, that's correct.
Where was that store located?
It was located it was very close to our home,
And what city was the Big 5 located in?
Encino.
And you lived at that point in Sherman Oaks?
That's correct.
And with respect to the next page, actually go 2 pages to where Laurel Oziel is listed.
Yes.
Does that appear to be your wife's signature?
Yes, it does.
And the date is also November 6, 1989?
It is.
And does that appear to be her driver's license number?
It does.
Does that accurately reflect your address at that time?
It does.
And going to the last page. Actually, the last 2 pages are receipts, is that correct?
Yes, they look to be receipts.
And they're for 2 shotguns.
2 shotguns, yes.
So there was a total of 3 shotguns that were purchased by yourself and your wife?
There were 3.
Now, in your testimony regarding the October 31st and November 2nd sessions, you indicated that you were aware of some abuse by Jose Menendez. Is that correct?
I was aware of a lot of instances or a lot of characteristics that were abusing, yes.
What in particular were you referring to when you testified to abuse by their father? What kind of abuse? Would you relate that to the jurors?
Yes, I think that the,
Your Honor, I think at this point, we probably should have heard it some.
Is there an objection?
Yes.
All right, you may approach. Juries are not present. All participants are otherwise present. We were discussing the question that had been asked of the witness and the concern expressed by the defense of violation of potential patient-therapist privilege in relationship to sessions that occurred prior to October 31st or even subsequent to October 31st. Counsel have referred to certain portions of the transcript in relationship to the cross-examination. Did you want to be heard?
Has the court looked at 9980 and 9981?
Those were not pages that counsel told me to look at. 9980?
Yeah, 9980 and 9981.
Well, you gave me volume 63 or told me to look at 63, so I need volume 64 apparently. Is that right?
We cited some.
We are
All
going
right,
to
if we get
fast
volume
forward.
64, Penny from
we are going to fast forward through
Yes,
this so we can get back
abuse in his earlier.
to the juicy parts. Okay, I think this is all
Jury
for the
that-
argument.
You
Okay,
First November
Oh,
2nd,
let's
that
go
they
back.
killed their parents due to
have both juries out and
Okay.
we will continue the examination. And both juries are back and we'll
Both juries are
resume
back.
with the examination. Mr. Kuriyama?
Your Honor. Dr. Oziel, did either defendant tell you during the sessions of October 31st and November 2nd that they killed their parents due to physical abuse?
no,
Did either defendant ever tell you during the October 31st or November 2nd sessions that they killed their parents due to sexual abuse?
no, they did not.
Did either defendant ever tell you during the October 31st and November 2nd sessions that their parents posed any physical threat to them?
No, they did not.
Did either defendant ever tell you during the October 31st and November 2nd session that they killed their parents in self-defense?
No, they did not.
Thank you. I have nothing further, Your Honor.
Dr. Oziel, both Menendez brothers indicated to you in both sessions that they were suspicious that you were going to not keep the information they were telling to you confidential. Isn't that true?
No, it isn't.
That's not true.
No, it isn't.
And they were not suspicious during either of those 2 sessions.
That wasn't the question you asked, Mr. Burke.
Were they suspicious that you weren't going to keep the information confidential?
The answer is no. You asked whether they were suspicious. The answer is no.
Maybe I should rephrase it. Did they indicate to you that they were afraid that you were going to leak the information that they were giving you to other people?
The answer again is no.
Did
Overall, the
Did
answer
Lyle
will stand.
Menendez indicate to you at either the October 31st or the November 2nd session that words to the effect of what's going to prevent you from going to the police or other people anonymously?
Yes, he specifically stated that he was fearful that I could and believed that I could anonymously or some other way disclose the information.
And that is something he said to you on October 31st, correct?
It is.
And it was something he said to you in the presence of Erik Menendez, correct?
He did.
All right. Now, I believe you testified on redirect examination that one of the reasons that you recorded the notes was because you thought it was important for you to get documentation in a safe place. Is that one of the reasons you had for recording the notes?
I believe that would be a restatement of what I said.
All right. And is it true that you may not have recorded those notes until March 9th, 1989?
No, that's not true.
Didn't you testify on cross-examination November 9th?
Oh.
Sorry.
November 9th. It's possible that I may not have. I think I said a day or so up to about the point when I purchased the shotguns, which I just see in front of me. The record shows it's November 6th, sometime around November 6th.
All right. So one of the reasons for recording the information was it was important for you to get the documents in a safe place, and yet you may not have recorded those notes until November 9th, 1989, correct?
Yeah.
November 9th, I think, would be the very outside date. I believe they were recorded prior to that, but yes, I believe that's correct.
And
I would
as
think it would
far
be
as
very
getting the
important to
documents
get that
in a
written
safe
down.
place, if you recorded them on or about November 9th, where is it that you put the documents on or about that date?
In the safe in my house.
Right. And the house was the place that you testified Erik Menendez had been to and knew where you lived, correct?
That's correct.
And as far as you knew, there could have been the ability on their part to come in, break in the house, and get inside your safe, right?
The answer is that was a possibility, but by that time, I did not believe that that was going to occur. That was my fear the first night. I didn't believe at the time of November 9th that it was likely they were going to break into my house and take the tapes.
Why?
When did you decide that that likelihood didn't exist?
I couldn't answer that question.
Just roughly.
I'd be speculating totally. I don't recall the exact moment or anything like the exact moment that I decided that. I think that my fear about them imminently killing me that moment was pretty much October 31st. It diminished to some extent November 2nd when we had the conversation about the notes and the tapes and being in a safety deposit box. And I think after November 2nd, I wasn't as concerned that they were going to break into my house and take things in the house that related to.
That seems inconsistent with what he was saying before.
The contents of notes in my house.
So by November 2nd, that fear had diminished? Is that a
By November 2nd, the specific fear that they were going to break into my house and rummage through my house to try to find documents had diminished.
And it was sometime after November 2nd that you went to Newport Beach, is that correct?
I believe so, yes.
It would have been the weekend of November 4th, correct?
That's correct.
And you've already told the jury that the reason you went to Newport Beach was because you feared going back to the house, isn't that true?
That's correct.
And that would have been after this November 2nd date where you say your fear had diminished as to their ability to break into your house, correct?
No, I didn't say my fear diminished as to their ability to break into my house, Mr. Burt.
Your fear had diminished about what?
My fear had diminished in relationship to their motivation being the very night they confessed to me, killing me and trying to rummage through my house at the same time. That was I only had 10 minutes to be thinking of these things since after the session, I had a period of just a few minutes to make decisions. And that was my feeling that first night. By the time I went to Newport Beach, I just wasn't feeling as concerned that was the action they were going to take.
Well, but somehow you must have been concerned they were going to take some action that involved breaking into your house, correct?
I was by that time, I was much more fearful that they simply would be planning a way to kill me.
Well, you said that you took all these protective measures and you described how you got a security system upgraded, correct?
That's correct.
And that security system wasn't upgraded until November 16th.
Oh,
That you've stated that, and that may be what some record indicates. But I recall that we took measures before November 16th that may not be reflected in whatever records.
yeah,
you
but
have.
records are
And
records.
If the police department interviewed your security company and they told them that your system was upgraded on November 16th, would that be false?
No, I'm not saying it would be.
Recollection?
No, I'm just saying we may have taken measures that didn't involve having our security company come out. That's all.
And why were you buying the shotguns on November 6th?
for personal protection.
at your home, correct?
That's correct.
And
That was
on
after November 2nd.
6th.
Yeah,
That's correct.
after
And
November
so at
2nd.
least by November 6th, you must have still feared that there was some idea they were going to come to your house, correct?
Yes, that's correct.
And so you kept the tapes in your house on or around November 9th, correct?
That's correct.
And when did you finally remove them from the house?
I don't have any recollection of when they were finally removed from the house.
Well,
I wasn't very concerned about the issue of the tape recordings from a standpoint of protection once they were made. Once they were made, Lyle and Erik knew they were made. I was they weren't protective in relation to being in a safety deposit box or being in my house. It wouldn't have mattered where they were. The point is, Lyle and Erik knew they were made, and the fact of their knowing they were made is what was protective, not where they were stored, Mr. Burke.
now, when did you first tell them that you had notes of that session? The
Sustained.
session of October 31st or November 2nd?
May have told Erik something about keeping notes when Erik was there alone on the 31st, told Lyle and Erik about the notes on November 2nd.
And on that date, you also told them that the notes were in a safety deposit box, correct?
That's correct.
And you told them that your attorney had keys to that safe deposit box, correct?
That's correct.
And that was a lie, was it not?
That was a bluff to save my life, yes. If you want to characterize it as a lie, that's fine, Mr. Burke.
Well, you were giving them false information,
It was a
correct?
bluff that was false.
And the motivation for giving them false information at that point was
To save
protect yourself.
my life, yes. That's correct.
In other words, to further what you perceive to be your best interest, you were giving them false information.
My best interest, my family's best interest, other people's best interest, absolutely in relation to trying to save my life, I did proffer false information.
And how long did you keep the tape inside your home?
I don't recall.
Well, what happened to it next? Where did it next go?
I think it next went, well, first of all, I think I continued to record sessions as a,
Objection, Your Honor.
Let's have the question read back, please.
Question, well, what happened to it next? Where did it next go?
Your
Why
Honor,
don't
may
you
I
ask that,
approach?
answer that question? No, you can answer that question.
ultimately, the tape next went to the safety deposit box.
And I think you were shown the safety deposit box indicating that,
Excuse me, correction. I have to correct my testimony. I think it went from that location to be duplicated at Smith's duplication facility, just temporarily for me to watch her duplicate it. Then, at some point after that, it went to the safety deposit box.
and when was the tape duplicated by Judalon Smith?
I don't recall.
And is it true, based on the entry into the safe deposit box, that you first went there on December 7th, 1989, based on your previous testimony?
Yes, I didn't go there. My wife put the tapes in the safety deposit box.
And do you remember being shown the safety deposit box log,
Yes, I did.
and that the first entry after July of 1989 is December 7th of 89?
I don't recall that, but if you're telling me that, I will accept that that's when it was.
All right. And is it your testimony that you were still in fear of the Menendez brothers on that date?
Yes,
In fact, you, according to your testimony just here today, were still in fear of them on March 8th, 1989, correct?
that's correct.
And
But then you said that you weren't in fear of them.
A greatly diminished fear, but it was a fear, yes.
well,
He's all
do you
over the
remember around March 8th, 1989, having a conversation with Judalon Smith?
I'm sure I did, but I don't recall any specific
Do
conversation.
you remember Judalon Smith saying to you in a conversation on or about March 8th, 1989, 1990, Jerry, if those boys aren't caught, they're always going to be out and they're always going to be a threat. And your answer, Judalon, they're not a threat. They're not a threat. But if you keep stuff about them, you're going to be in the files. You're going to be absolutely documented in the files. Do you remember making that statement to her?
No, I actually don't.
If you made that statement, would that be a false statement on your part?
No, I don't even understand what that statement would mean.
Well,
I don't.
do you remember threatening to put Judalon's name in a file that you had?
Wow.
The only
Wow.
thing that I'm aware of is, I mean, first of all, her name already was, and as far as I was concerned, something that they could have learned about. But I don't remember the context of this conversation at all. It was 4 years ago, and I think she called me multiple times. I don't recall this particular interaction.
Do you remember telling her that, Judalon, everybody that I believe in any way might know something about this is going in those files? Remember making that statement to her?
No, I don't. But the only one who knew anything about that was, in fact, Judalon.
I object to the last part of the question, it's not disclosed.
Objection sustained. The latter portion of the answer is stricken.
And remember in that same conversation saying to Judalon Smith, Judalon, what are you going to do with the stuff that you have? Because if you're not going to do anything about it, then you're going to have to go in a file. The first thing I'm going to do tomorrow morning is, if I don't get complete cooperation from you at this point, is create an entire file
Jesus.
that documents all the stuff you've done, all the stuff you revealed. And she says, Jerry, this is blackmail. And you say, no, this is not blackmail. And she says, yes, it is. And you say, no, it is not blackmail. And she says, if I don't give you my complete cooperation, you're going to manufacture a file. And you say, no, the file has to do with the people that I suspect. Do you remember making that statement to her?
No, I don't remember making the exact statement, but I know what it refers to, and it doesn't refer to anything that you're alluding to at all.
Your Honor, I'd object and strike the non-responsive part of the answer.
Objection overruled. The answer will stand.
Do you remember telling her that you were going to create an entire file that documents all the stuff you've done, all the stuff you reveal?
Yeah.
Objection vague and irrelevant.
Overruled.
So,
I remember telling her I was
so
going to create a
controlling.
file, but not having to do with what you're alluding to at all.
And do you remember that she was tape recording that conversation you had with her?
Whoops.
I didn't know that she was tape recording it. No.
whoopsies. And by the way, Sandra Ramirez, thank you so much for gifting 5 Legalbytes memberships. Very kind of you. We've got a lot of very generous gifters today. And to the folks that in the chat that are now members of Bite Club, welcome to Bite Club. And I hope to see you on Friday during our casual Friday members only live stream at 10 a.m. East Coast time. So anyway, let's continue.
Did you want me to
Thanks,
explain what
Sandra.
it alluded to?
You can do that and redirect.
Okay.
Don't you want to ask me a very specific question that helps me out? No, that's not in my interest. I'm not going to ask you the question that you want me to ask. I'm going to ask the question that I want to ask.
Now, doctor, with all these protective measures you were taking with regard to your house, did you feel at some point that it was safe to go to the police?
No. Well, no, I didn't, and I didn't want to go to the police.
You were shown a bunch of letters that Judalon Smith wrote to you, correct?
That's correct.
And do those letters, in your mind, show that she had certain feelings for you?
Yes, they do.
And do they also, in your mind, conclusively show that you were not obsessed with her?
I don't know that those letters in and of themselves conclusively demonstrate that, but it certainly is true that I was not.
Well, you brought these letters to court, correct?
No, they were requested of me by the district attorney's office.
And was a request to basically bring letters that you thought illustrated the point that she was obsessed with you?
No,
What was the request?
to bring any communications from Judalon Smith that I could find as quickly as I could gather them together.
And you said you had a lot more of them home, but you didn't bring those. And in fact, there were some better ones than these, correct?
Objection, this states the testimony.
Sustained.
Did you say that you had other letters at home along the same lines as what these letters were in terms of the themes that are illustrated in the letters?
Yes, I did.
Well, was there some reason you didn't bring those letters?
Those were brought. It was the decision of the district attorney's office which letters that they were. First of all, it was the decision of the district attorney's office whether to read any letters at all. Not my decision. I didn't suggest that. And secondly, it was up to them which letters they selected to be read or the fact that they were read at all. I had nothing to do with any of that.
Right. And in your mind, do these letters show, as I asked you before, that Judalon Smith had certain feelings toward you?
Yep, ask Manson. I tried.
Well, on the objection that you've stated, the court will overrule the objection on that ground.
He's like, there might be another objection that you can try that maybe I would.
She's not going to try again, so
No,
go
I
ahead.
was
He's asking for her again. No other objection?
Doctor, did these letters in your mind?
Anytime he
show
does that, he's
Judalon
like, on
Smith
that
had certain
objection
affection and feelings?
overruled.
These letters and all the rest of the letters and all of the context of the entire relationship absolutely demonstrated that she had more than affectionate feelings towards me.
And did they also, in your mind, absolutely show that you were not obsessed with her? Did they bear on that issue at all, in your mind?
I don't think that that those letters specifically demonstrate that, but I'm sure that if Judalon Smith has any letters that demonstrate that I was obsessed with her, I'm sure she'll produce them.
Well, again, they don't bear on that question at all, do they? On your obsession.
I don't know that they do. It's not for me to decide these things.
And the letter, one of the letters is the October 89 letter, which Mr. Kuriyama quoted to you in part, correct?
Which letter was that?
Part.
The one that you dated, 1089. Do you have that there in front of you?
Well, that you
well, I
dated.
might. I think there were two 1089 letters, Mr. Burt.
The one that starts 1089, Dearest Jerry, and there's some printing. Let's just see how beautiful we can make it grow. You see that one?
Yes, I do.
And he quoted you the end of that, which says, I'm trying
Okay.
not to drive you
Can you
crazy.
get some more
and
context?
to grow emotionally myself, correct?
Yes, you did.
And then he quoted, I love you. Do you know how wonderful and thoughtful and fun and loving and special you are? Do you remember him quoting that to you?
Yes, I do.
He left out a paragraph, didn't he? In between the portion he quoted and the last portion.
Okay.
Yes, you did.
But read to the jury the part he left out.
Yeah, let's do it. Let's do
There are
that
some
paragraph.
days I could just park a well-fed pigeon right over your head, a la Larson.
And do you know what that has reference to?
That doesn't sound obsessive.
I could make a wild speculation, Mr. Burt.
That does not sound obsessive.
And you say during
That sounds like a
entire
woman that,
period of
that
time,
is genuinely in love.
Basically until the time when the police, when she moved out of your house, you were trying to get away from her, correct?
I don't believe that was my testimony.
Well, was your testimony that you've been trying to break away from her all along? Do you remember saying that?
Yes, all along, if I were to clarify that, I definitely wouldn't say I was trying to break away from her from the first day or first week or first month. What I really meant is after I decided that this was getting out of hand and in relationship to anything that I thought I was ever communicating to her, from that point on, I was trying to find ways to break off the relationship. So I would say that from several months into the relationship through the end of the relationship, I was at different points trying to break off the relationship.
And you also said
I'll buy
she
it.
was pressing you not to be in your marriage and basically bringing a lot of pressure to bear on you, correct?
Very frequently and very repeatedly.
And you also said, both here today and yesterday in cross-examination, she was fixated on you, correct?
I think that's, I don't know if that was a term that was in the press conference, but yes, I believe that she was extremely attached to me. Is maybe the way.
And you categorically denied that you were pursuing her in any way, correct?
I don't know that I categorically denied that I had any role at all in there being a relationship. I think that would be an untrue statement, and that's not usually how relationships are formed. What I was testifying to is that I was not pursuing her initially or trying to get a more committed relationship with her in any way. As a matter of fact, I wanted a very limited relationship with her and thought that's what I was communicating.
I think you
She
wanted a
tried
very
to take the relationship
controlled
and bring it
relationship with
into
her.
an area or level of commitment or involvement that I absolutely didn't want. That's what I meant to testify to.
And when I was asking you about all those phone calls you made,
David
you were
Puff,
trying to
they
make
both
the
have
point that
cross-examined
she was
this
the one
witness.
who was
Yeah.
actually
You're not misremembering.
causing you to make those phone calls. Isn't that true?
No, no one caused me to make the phone calls. What I was trying to testify to is very simply the fact that
I object to all the rest is not responsive. I think there was a-
Objection sustained. If you could just confine your objection to the legal objection, basis for your objection. All right, your next question, please.
You were explaining when I asked you about those letters and, excuse me, could I have 1 minute here?
Certainly.
Yeah, I think he wanted a controlled relationship with her,
I was asking you about the phone records.
and she wanted to expand it, and he wanted it very controlled. That's the impression that I have.
And your explanation for all those calls, this is at page 10,069, was 64.
What line?
This is line 27 at 10,069. You said, Dr. Oziel, one of the reasons I was making all of these telephone calls, or a lot of them, had to do with Judalon Smith obsessively calling me and wanting reassurance and trying to elicit me calling her. And in addition, she couldn't call me at my home, so she asked me to call her very frequently. So it was at her request that I made these phone calls. Do you remember that?
if that's what I testified to, I shouldn't have said obsessively calling me, because the fact is that I had an agreement with her not to call me, because she only could have called me at my answering service, where she wouldn't have been able to leave me any message in any event, or at my home, which I specifically instructed her not to call. But other than that, I think the answer is correct.
Well, that's false testimony, because you did tell her to call you at your home. Did you not?
Sustained.
Is that false?
Yeah.
Rephrase the question.
Is
Yeah,
it
but-
false testimony? Because didn't you in fact tell her to call you at your home?
I don't
There you
recall having told her to call me at my home, and I think she called me at my home a total of maybe once or twice throughout the course of the, or several times throughout the course of the relationship. So I don't recall that. I'm not saying it's false or not false. I don't remember it.
Well, do you
Certainly.
remember on calling her up and you saying on her telephone answering machine, "Are you there? And I'm just getting ready to leave in about 10 minutes. So if you can call me by 7:10 or something like that, we could talk. Otherwise, we won't catch each other, and you'd have to call me at home." Do you remember making that statement on a tape?
Objection made.
Yes, can you be a little more specific?
Yes, in March. Do you remember that?
Oh, in March. By March, that would have had a completely different meaning altogether, Mr. Burt. That would have had to do with the whole situation of her turning in tapes to the police department by March. And by March, she'd already been in my home. So that's I think that's
Jenny,
again a
yes,
distortion
I believe we will be
that
hearing from
completely
her.
misleads people in relationship to what occurred.
So would it be fair? I don't have objection to that answer. So would it be fair to say?
Wait. We have one objecting, the other not objecting.
I'll withdraw the objection and let
All right.
Mr.
This is what happens when you have
The
two
objection is
trials
overruled
overlapping
and
at the
answer
same
will
time.
stand.
Would it be fair to say that your relationship changed in that regard? In other words, around March, there was more free-flowing communication between the two of you in terms of your ability, her ability to call you at home and your ability to call her back in the presence of your wife.
I would say that would be true.
Okay. And would it also be fair to say that in the early part of the relationship, that is from June of '89 forward, that if you look at that time period, June '89, say to December '89, that she was the one who was being obsessive with you?
Yes, she was being obsessive with me, but I'm not relating to phone calls as any sort of a way of describing obsession at all. I think it's completely misleading.
And I think what you described for the jury on numerous occasions is during the period between June of 89 and December 89, your basic stance was one of trying to get away from this woman.
No, that misstates my testimony.
Well, what is your testimony in that regard?
I believe I just testified that it wasn't from the beginning of the relationship in June that I was trying to get away. I think I said that beginning several months into the relationship, sometime I believe in maybe September, I began telling her that I thought this was not a good idea, that we should never have moved it from a business a relationship into a personal relationship, that she was responding much too seriously to it in terms of wanting something out of it that wasn't going to happen. And from that moment on, that's the basic stance that I had with her. And I did try to sever the relationship altogether on numerous occasions. And her typical response to that was to threaten suicide. And on in one event, she actually did ask me over for a meeting at a time when she had actually made a suicide attempt or gesture. I don't know which it was, but she definitely was in the process of looking like she was attempting suicide at the time that she called me over to her place.
And when were you attempting to break it off in terms of time period?
I think I've just testified to that.
Could you, around September?
Around September, certainly, from sometime in September and October is the time that I recall having.
All right, Mr. Burt.
Doctor, do you have that document in front of you, which is the June letter from Judalon Smith, the business letter regarding her tape business?
Yes, I do.
And what is the date of that letter?
That letter is dated June 15th, 1989.
And to your mind, was that letter brought up or brought in by you to show that you had a business relationship with her?
No, as I told you, the district attorney's office asked me to bring in whatever documents I had around, so I didn't bring any letter in for any particular purpose. I brought them all into the district attorney's office, and they decided what to do with them, if anything.
Well, that's a letter you released to the press during your press conference in September of 1990. Isn't that true?
Yes, I believe it is.
And what was the purpose of releasing it to the press in September of 1990?
To establish that she had solicited me for business purposes.
And to establish that your relationship was a business one.
Was in part a business one, yes.
Well, you represented in that press alert, that media alert in September, that your relationship was strictly professional, did you not?
No, I don't believe I did.
Well, did you represent that you were involved with her romantically?
I don't know or recall what the press release said or press conference said, but I don't recall it having said that I only had a business relationship with her and didn't have any personal relationship with her.
Did you say in your press release in September of 1990, she called me with a straight business proposition to produce a series of behavioral therapy tape cassettes in areas of my expertise?
Mr. Burt, I don't have my press release, so if you could show it to me.
Sure. This is exhibit. Bottom of the page.
Okay. Yes, that's what it says.
All right. And it's true, is it not, that shortly after, and you released that letter to the press, that is the June letter, to prove your point that it was a business relationship?
Well, I think the firm that was representing me released the statement to the press to basically respond to a televised segment that had a number of miscommunications or errors in it. So I think it was a clarification, and this was just one part of the clarification.
And it was the firm that released it. You had no responsibility or involvement in that at all? Is that your testimony?
No, I didn't say that. You simply said I released it, and I did not specifically release it.
What you mentioned the firm as having done that, correct?
That's correct. That doesn't mean I had no responsibility for it.
All right.
Didn't state that.
Did you have some responsibility for releasing that letter?
Sure I did.
By the way, I noticed when you were asked to look at those documents on the firearms transaction, you immediately identified your signature, correct?
Yes, I think I did.
Was there some reason why you had trouble recognizing your signature on the letter you wrote to for Judalon Smith yesterday when I asked you whether that was your signature?
Yes, there was.
What was the reason?
Didn't look as much like my signature.
Do you still believe it may not be? Or do
No.
you believe it may not be?
I think I already testified to that, Mr. Burke.
And is it true, Dr. Oziel, that beginning around Judalon Smith's birthday that you started sending letters to her?
I may have sent some letters to her.
Oh.
And that was shortly, do you know what her birthday was?
No, I don't
Date.
recall.
Is it around July
May have
8th?
sent some letters
May
to
have
her.
been.
And
Can we read those
did
letters?
you send her a letter around July 8th, 1989,
I may well have.
expressing to her at that time certain feelings that you had for her
I may have.
and showing you Exhibit 122?
I want to see the letters.
Specifically,
Let's read them.
the first page of that exhibit.
Give me these
Do you
letters.
recognize the handwriting on that letter?
Yes, I do.
Is that your handwriting?
That's my handwriting.
Is that a letter that you sent to Judalon Smith as a birthday card?
Shall I read it over to determine whether I sent that?
If you could, yes.
Okay. Yes, I sent that.
And that was sent to her on or about July 8th, 89.
That sounds about right.
And you said in the letter in your own handwriting, well, you keep talking about children. You are a new and special friend who feels much, much more familiar than that. I sense your need and ability to care, to be kind, to love. I see you've learned much and are trying to use what you've learned. You are an honest, open, bright, creative, sensitive, and perceptive woman. There's much in you to admire and treasure. Thanks for letting me into your world, and a very happy birthday, Jerry.
That's correct.
And by that time, that is on or about July 8th, 89, had your relationship changed from one of strictly business to something else?
I think
Yeah,
that,
Definitely doesn't
first of
sound
all,
like business.
there certainly was no sexual relationship involved that I can recall at this point at all. I think that, yes, it had. I think that we'd spent a lot of time talking
no-
about both
that-
business and
that's what it looks like
personal
without a
things.
sexual
She'd shared
relationship?
a lot of feelings with me, and I'd shared a
Okay.
lot of feelings with her. I think I've already testified that for the first several months of the relationship, that we had an involvement, and I think I testified that sometime around September, October, I started wanting to break off that involvement. So this would be very consistent with what I've said.
And is the next document in that exhibit also a
Let's read the next one.
letter written in your handwriting?
Yes, it is.
Does it say, "Dear Judalon, happy birthday a second time. Just a few things to let you know someone remembered. I wish for you lollipops and roses, real love, peace, freedom from worry, good friends, good health, and all things good on your birthday. You are a survivor, yet you are fragile and delicate. You have strength, yet you are very feminine. You are unique, loving, caring, sensitive, sweet person. Really much too sweet for this world much of the time. You are a part of the universe I've never really experienced before. You are very new for me, and I wish you only love." Signed, Jay.
Yes,
Lollipops
there's no
and
date on this.
roses,
I'm
eh?
assuming that this relates to some card. I don't know.
Well, it identifies
As
itself
a birthday,
as a second birthday card, right?
That's
So you
how I
sent her
talk to my
that
business colleagues.
around July 89.
assuming I wouldn't have sent her one July of 90. Yes,
Okay.
that's correct.
Well, did you send her one July 9?
I'm saying I'm assuming I wouldn't have sent her one July of 90.
And then is it your testimony that your relationship changed after those letters were sent?
No, it's not my testimony that the relationship with her changed immediately after these letters were sent.
Well, sometime around the end of the year, I think you said, was when you were attempting to break it off, right?
Yes, that's correct.
And is there a letter in there dated January 8th, 1990 in your handwriting? January 8th, 1990?
Yes.
1 second, real quick. Question about elevator buttons behind him. I haven't seen them. I've been trying to look for them since I saw this chat. They're those. If they look like elevator buttons, they might be for wheelchair access, possibly. Because in California, there's a lot of spaces that they'll have stuff like that for wheelchair access. It wouldn't surprise me in this case if that was it here. Or, alternatively, for when you have a witness that just goes up in flames so terribly that they just need to make a very quick escape. That's obviously a joke. That's a bad joke. Anyway, let's go on.
Yes, there is.
You're laughing. Aren't you?
I'm laughing because I know the context of this and what happened, and it's very humorous.
Is this whole proceeding humorous to you?
Mr. Burt, I never said that. I'm laughing at the letter, and you asked me if I was laughing at the letter. My response was no. Oh, was yes, I am.
Do you realize in this case that the Menendez brothers faced the death penalty?
Of course.
Overall.
Of course, I recognize that.
Is there anything funny about this trial itself to you?
How am I
Of
funny?
course, there isn't, Mr.
How am I
Burt.
funny?
All right. Is there a letter in your handwriting, January 8th, 1990?
Yes, there is.
And is that a poem which you wrote to Judalon Smith at a time which you've testified you were trying to break off the relationship?
Here's the poetry.
It wasn't a poem I wrote to Judalon Smith. Judalon Smith repeatedly told me that she'd never received a birthday card in the last 3 years from anyone. She said it would be wonderful to receive one. That's why I sent her two. And she also repeatedly told me that no one had ever written her a poem. And I was in her presence. I don't recall if it was her place of work or whatever. And she said, "Why don't you write me a love poem?" And I said, "What do you want me to do that for?" And she said, "I've never had a love poem in my life." I said, "Well, I really don't write love poems." And she said, "Well, why don't you make one up?" And I said, we had this long conversation about why she wanted me or needed me to write her a love poem. She said, "Because I've never received one before and I want one." I said, "Fine, great. I'll write you a love poem here on the spot." And at that point, I took out a pen and literally within a period of about 10 minutes, wrote this out and handed it to her. And that's how she got it. I guarantee you there'll be no letter or stamp or anything associated with this. It was handed to her in her presence within a period of 10 minutes after she requested it.
Okay. I first off, I don't buy that explanation. I don't buy that at all. Not at all. Number two, there's the buttons that we've been talking about. I don't know. That could be a projector, like for a projector, or I think more likely it probably is for disability access in the courtroom, but I don't know. Because that does look like an elevator. Okay, anyway.
And you dated that January 8th, 1990, correct?
I suppose I did.
At a time when you say you testified to this jury under oath that you were trying to get away from this woman, correct?
That's correct. My testimony was accurate.
And the last lines of your poem are, "For like a nymph, she strides from the forest at daybreak dressed in white, where no other man has truly known her, Judalon."
I can't read all that, but I'll stipulate that probably it says something like that.
I'm trying to distance myself from this poem here, man. I don't know. I can't really read it. I wrote it in like 2 seconds. Don't put it in my face, man.
Describe probationary status in 1986, correct?
That's correct.
And you explained to the jury your understanding of the severity and the nature of that particular offense, correct?
That's correct.
And I also think you explained to him that in fact you had 2 licenses that were revoked. Isn't that true?
Well, there were allied licenses when one was not revoked, Mr. Burke.
So you had a clinical psychology license from the Board of Psychology, did you not?
That's correct.
And you also had a separate license at that time, didn't you?
Yes, I did.
And what was the separate license?
Marriage, family, and child counseling license.
and there were actually 2 proceedings pending against you because different agencies handled those licenses. Is that correct?
No, in reality, what happened is that the Marriage, Family, and Child Counseling Board simply handed over the proceeding to the Psychology Board and stipulated that whatever they found the Marriage, Family, and Child Counseling Board would also accept. So they operate in tandem. If there's a claim with respect to one license, then the other board also automatically becomes involved with the same claim.
But there were parallel proceedings.
Not to my knowledge. To my knowledge, the MFCC board turned over the proceeding to the Psychology Board. And I never talked with anybody in any significant way with the Marriage, Family, and Child Counseling Board. They simply referred it over to the Psychology Board.
And Court Day also sued you in a court of law, did he not?
Yes, he did.
And you had a provision in your insurance contract which provided that your insurance company could not settle a lawsuit without your consent. Isn't that true?
I don't know if that's true or not.
Well, in this case, you were consulted before a settlement was reached, correct?
I don't recall. It was a long time ago, but that might have occurred.
And you ended up paying Court Day some money, didn't you?
No, I didn't end up paying Court Day any money.
You had no personal liability. Your insurance company had to pay off. Isn't that true?
The insurance company made some settlement with Court Day.
So basically, it was no monetary consequence to you
No, it wasn't.
because your insurance company covered it.
That's correct.
And I think you said that
Premiums
your
probably went up,
license, neither one of your licenses was suspended, correct?
No, I didn't say that.
Was either license suspended?
I think they were both suspended for the same period of time.
How long was it suspended for?
I don't recall. I think it was 30 days.
Seems like a
And-
short suspension. Whisper, 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 whisper.
And Dr. Schoen, you may I approach a little bit, Sharon?
What do you have there?
Marked as defendants next in order. Exhibit number 123, which is
I want more letters.
the decision and stipulation from the Board of Psychology.
I mean, we're going to get a lot more of something, right? Because we are getting towards the end of this testimony, I think.
Are you asking for another exhibit
this
to be marked,
portion?
Mr. Bird?
And we're going to start in on the next portion. But that's still going to be some time with this guy.
Science examiners. Department of Consumer Affairs, State of California.
I've been discussing the scheduling with council. We have some other matters yet to discuss, and it's now 4:30, so we'll have to continue
Adjourn for the
tomorrow
day.
with this witness's testimony, and then I'll discuss further with the attorneys other matters dealing with our schedule. But there's no need to keep you here anymore today, so I'll excuse both juries until tomorrow at 9 o'clock. Don't discuss this matter with anyone or form any final opinions about
All
it.
right.
And we'll have both juries back here tomorrow at 9 o'clock.
Okay.
All right, in regards to the scheduling then,
All right. We're not going to go over the scheduling. That's boring. That is boring. We are going to go directly into the last, I think. Oh, hang on. Sorry, an ad just started playing in my brain. We are going to go into the next portion of Dr. Oziel's testimony, which I think / hope is going to be the end of it. This portion is like 4.5 hours long. I'm assuming that there's going to be some kind of oral arguments in some portion of it. But we're not going to do the full 4.5 hours on this. We're going to do like, I don't know, maybe like another hour or so. But I totally went through and skipped through all the ads before, and now it's making me rewatch them. So I'm going to keep talking for a minute so that we don't have to all go through these ads together while we are watching this later. But yeah, the whole she was obsessed with me, I wasn't obsessed with her thing. I'm not buying it. Not buying it at all. She was sending him letters. He was saving them. He was writing the date down on them so that he could keep them organized, it seems. He also was, let's see, is this? Oh, okay. So I think we're potentially in the clear here with advertisements for today's portion. Anyway, so I'm not buying this whole like she was obsessed with me, I wasn't obsessed with her. I cannot wait to hear her testimony because I really want to see just how, crazy or unhinged she actually comes across, because if she seems very reasonable and very normal, and she has a very different perspective of what happened and how things happened, that is something that is going to be very, very interesting to see here. Okay. Here we go. I will get rid of that one, and then I will add share screen. This one. Okay. Boom. Here we go. And I will unmute that because now we actually need the sound. Okay.
All right. State your name again for the record.
Dr. L. Jerome Oziel.
I'll remind you, you're still under oath, and Mr. Burt, you may continue your recross examination.
Thank you. Dr. Oziel, yesterday you testified that you had 3 explanations for why you recorded the October 31st and November 2nd sessions on a tape recorded cassette. Do you recall that testimony?
I recall that I stated that, yes.
All right. And your 3 explanations were that, number 1, that it was important for you to get the details for therapy purposes, correct?
That's one.
And the second one was you wanted to document your actions, I think is the way you phrased it. Do you recall that?
I don't recall if I phrased it that way, but that sounds correct.
What did you mean by that, document your actions?
Just document what happened and what steps I took in terms of dealing with the situation.
For what purpose?
For the purpose of keeping notes of what transpired in the session, what was said, and how I responded to it in my role.
And the third explanation you gave was that it was important for you to get the documents in a safe place. Do you remember that?
I do.
All right. Now, were there also 2 other reasons why you made the tape recording?
I don't know what you're referring to.
Well, did you make the tape recording for the purpose of creating a false record so that you could use the tape to extort money out of the Menendez brothers?
No, Mr. Burt, I did not.
And did you also create
Did he get a haircut
false
the day before?
tape in the sense that you had false information on that tape for the purpose of using the information
His
on
hair
that
looks
tape
shorter.
to control your
Just
wife and your
realized that.
girlfriend?
No, Mr. Burt, I did not.
Now, you testified, I think, under oath in cross-examination with Ms. Abramson. As follows at page 9869, which is volume 63. Sure. Line 17. Yes.
Leslie definitely feeling the
Remember Dr. Oziel
Miss
testifying,
Frazzle
question,
vibes
and
today with
isn't
her
it true
outfit.
that over the course of your relationship with Miss Smith, you frequently threatened her to control her behavior by telling her aha, I'm going to tell Erik and Lyle that you know their secret and they'll come kill you. Didn't you do that? And your answer, quite to the contrary. Remember that?
Seems like what I testified to, yes.
And is that still your testimony? That is that you did not use the Menendez brothers to threaten and control Julian Smith?
It would be my testimony that that's absolutely true. At the time that she was threatening to turn in the tapes or disclose to the police about the existence of the tapes, I definitely told her that I thought that that was an error. And I told her that if she turned in the tapes, I was concerned that both her life and my life and the lives of my family would be at peril. So if that's what you're relating to, I definitely told her that throughout that period of time.
Well, was there a period of time where you were telling her that you were going to leave messages for Lyle to come and kill her?
Absolutely not.
You sure of that?
To leave messages for Lyle to come and kill her?
Right.
No, I didn't.
Right. Do you remember an occasion between October 1989 and March 1990 where you and Miss Smith were in her bedroom and you were singing some songs to her in an Elvis Presley imitation voice?
What?
No, I do not.
Do you remember Miss Smith saying to you, in answer to your question, well, who'd you think it came from, Elvis Presley? And Miss Smith saying, yeah, I'm going to write the Inquirer and tell them. And you said that Elvis is alive and singing songs in my bedroom, that's good. They'll put you away in the loony bin for sure. And Smith saying, I'll send them a videotape. And you saying, yeah, right, I'll kill you, or I'll just leave a message for Lyle. Do you remember making that statement?
No, I don't. But if I did, it would have been a joke. But I don't remember making it at all.
So
It would have been a
you
joke?
didn't make it, but if you did make it, it was a joke, is your answer.
No, my answer is I don't recall any of that conversation, but I definitely wouldn't ever have said anything like that had I ever said something like that and meant it seriously. But I don't recall anything having to do with that conversation.
Recorded?
So again, your answer is twofold. You didn't say it, but if you did say it, it was a joke.
Objection, this type of testimony.
Sustained.
Did you make that statement over the telephone
I don't recall having made that statement at all.
in any way, shape, or
No,
form?
I could have made it on the telephone. I mean, if I could have, I don't know if the statement is there somewhere,
Care,
then
that is great.
you know,
can't
I don't
wait to
recall
hear
it.
that.
In other words, if there's a tape recording with your voice on it, would you agree that you made the statement?
I'd have to hear it, Mr. Burt.
Well, if someone who's familiar with your voice listened to the tape recording and testified to the circumstances under which that tape was made and said, this is Dr. Oziel's voice, would you accept that? Or would you say, I never made that statement under any circumstances?
Objection calls for speculation.
Sustained.
Is it your testimony that under no circumstances did you make that statement?
It's my test. I'm sorry.
Objection, this statement is testimony. Asking
He's asking him.
Sustained.
No. What? Come on. He's asking him if that's his testimony. How does
Now,
that
Dr.
distinct
Oziel,
testimony?
I think you testified yesterday that on March 8th, you still believe that the Menendez brothers posed a threat to you. Is that correct?
That's correct.
And on that date, did you tell the police who were serving the search warrant at your house that you were the only one threatened by the Menendez brothers?
I don't recall.
If you did say that, was that a true statement?
I think what I was feeling at the moment was that I particularly would be a target. And I don't recall having said it, so I can't speculate as to what I said or why I would have said
Sounds
it.
like
But
he's told
I can recall that my
different things to
feeling
different people
was
based
that
on what's convenient.
if, in fact, Lyle and Erik felt that I voluntarily turned in the tapes, and they perceived that as a betrayal in the sense that I voluntarily turned them over to the police, that they specifically at that point would have been targeting me and not anyone else.
Well,
I move to strike the answers now.
I join.
Objection sustained. The answer is stricken.
My question is,
Anytime something is stricken, ladies and gentlemen, you are to disregard it, whether it's now or any other time.
Dr. Oziel, let me re-ask the question, which was, if you said to the police on March 8th, 1989, that you were the only one threatened, if you made that statement, was that a true statement?
At that moment, that may have been what I was feeling, and that may have been a true reflection of my feeling at that moment in relationship to the tapes being turned over.
All right. And so would it be fair to say, based on what you just said, that at that moment, that is March 8th, that Miss Smith was no longer in danger?
No, I wouldn't state that.
You wouldn't.
No.
If the statement was, I'm the only one who's in danger, if you made that statement, that would be a true reflection of your feelings, but that
In that
would
moment?
also somehow include Miss Smith in that statement?
No, I think at the moment that that I made the statement, that was my feeling. And so, I mean, if I made that statement, then that must have been my feeling at the moment. I'm not.
And is it your testimony that the next moment,
bullshitty.
literally the next second, your feelings changed and it was not only you that was threatened, but also somebody else?
I can't really document from moment to moment how my feelings changed 4 years ago. I can tell you that my primary concern, at the moment that the police seized the tapes that I had been trying to protect and keep in a safe deposit box and not to turn over to anyone, was that the Lyle and Erik would conclude that I had turned in the tapes voluntarily to the police, which all along is what I had labored to not do.
All right. So is your answer that your feelings from moment to moment as to who was threatened was changing on March 19th?
I think.
Excuse me, on March 8th.
Yeah, I think my testimony would be at that moment I was in a state of a lot of concern and a lot of fear, and I don't recall what my feelings were from moment to moment 4 years ago. I only recall that I definitely had a significant level of fear at the moment that the police and a number of other people were in my house with a search warrant seizing the materials that I had tried hard to protect and keep secreted all that time.
And were you trying hard on that date, that is March 8th, to keep them secret and protected so that no one else could listen to the October 31st, November 2nd tape?
Yes, I was.
And did you volunteer to anyone that they listen to that particular tape?
No, actually, it was quite the contrary.
In other words, at no point in time did you say to the police, listen to the October 31st, November 2nd tape, or words to that effect?
No, I didn't state that. What occurred is that the police demanded that I play the tapes.
All right, the objection is sustained. The answer no will stand. The rest of the answer is stricken.
Did you volunteer that the police listen to the October 31st, November 2nd tape on March 8th?
Objection irrelevant.
Overruled.
No, I did not volunteer it.
Fine. And on that date, is it true that if you made a statement that I'm the only one threatened, that that statement may not have been accurate as to other moments, other than the moment that you were making that statement?
It may not have been a complete and accurate statement in the midst of my being very fearful about what was going to immediately happen. It was my feeling is what I was stating.
All right, so it could be you didn't make the statement. If you did make the statement, it only reflected your thoughts at that moment. And if it didn't reflect your thoughts at that moment, then you were fearful, and that's maybe why you made the statement. Would that be a fair summary of all your explanations for that?
I don't know if that's a fair summary or not.
Well, after the emotion of the moment went by on March 8th and the police left your house, did you still think that you were in fear of the Menendez brothers?
Yes.
And did there come a time on or about March 8th, 1990, when you learned that Lyle Menendez had been arrested?
I don't recall when I learned that Lyle had been arrested.
And did you learn at some point that Erik had been arrested?
At some point.
Was that shortly after the police served a search warrant at your home?
I don't recall the time period, but sometime afterwards, yes.
Well, and when you say sometimes, I'm not trying to pin you down to a date, but would you say a couple of days as opposed to maybe 2 weeks later?
I don't recall when they were arrested. I couldn't tell you if it was 2 days or a week. I don't recall.
Did you, after they were arrested, think that you were still in danger of them coming over to your house and killing you after they were in custody?
No, I didn't think that I was in danger of them coming over to my house and killing me.
I kind of feel like we
Did you think Miss Smith was in danger after they were arrested?
went through this.
Potentially in some danger.
Like we
How
can
did
move
you
on.
think she was in danger?
Well, the police had told me,
Overruled.
the police had told me that that it was possible that even if the Menendezes were not themselves free, that there were still ways that that I could be harmed, or that that I could be harmed. And I construed that if there were ways that I could be harmed, then maybe there are ways that other people could be harmed.
They didn't specify, though, how that could take place, correct?
Yes, they specified that it could be arranged.
Did they say how it could be arranged?
I don't recall the specifics of it. They simply led me to believe that there were still possibilities. That, as a matter of fact,
Leslie just shaking her head.
All I recall is that they led me to believe that there was that possibility.
Did you think the police were maybe threatening you at that point, in addition to
Everything
the Menendez
she's
brothers, by
non-verbally
telling you that
communicating
information?
is you're piece.
No,
you're,
I didn't
you're
think
just
that.
you're a piece of shit. Like you're
And
lying.
did you think that
You're full of it.
it was your duty to warn Miss Smith that there were still some dangers lurking in the background at that point after they were arrested?
I don't recall my feeling at that particular moment.
It was at that point in your relationship, I think, that you said that you had made a decision to break off with Miss Smith. Isn't that true?
I think that I had already broken off with Miss Smith,
It was already over, the relationship, correct?
to the best of my belief.
And if I understand your testimony yesterday, there was this long period of obsessive concentration on you by her. And then there was a period right around March 8th where you had a concern for her because she disappeared, right?
Yes, that's correct.
And you said the phone messages which we played for you were a distortion of whether you were fixated on her, because it really only reflected your fixation on her at that moment, at a point in time when you were concerned for her safety. Would that be a fair summary of your explanation for that?
Overruled, since this was covered by the prosecution on redirect.
I don't even recall the question, Mr. Burt. Could you repeat it?
It's kind of a long question.
Yes, I could repeat it. Would it be a fair summary to say that your relationship with Miss Smith was characterized by a period of time between the time you met her, I think you said in June, until March or around in there, where she was fixated on you and pursuing you, and you were attempting to get away from her? Let's take that part of it first. Would that be a fair summary of the period of time from the time you met her up until the phone messages, which we're going to talk about in a moment?
No, that would be a misstatement in my testimony
And how would it be a misstatement?
in a number of ways.
Well, did you testify that during that period of time she was pursuing you and you were trying to get away
Break
from
it into
her?
smaller chunks.
No, I didn't say I was trying to get away from her.
Pardon?
I didn't say I was trying to get away from her.
But there was a period of time, and I think you testified your reason for revealing to her the content of the October 31st and November 2nd session was because at that point in time, she was in a relationship with you where she was compulsively fixated on you.
All right, I'm going to sustain the objection as to asked and answered, because the area covered by the prosecution related to the answering machine tape, and
All right.
counsel will have to confine his examination to that area.
Is it fair to say, Doctor, that with reference to those answering machine tapes, that you said that your voice on those tapes and the repetitive nature of you calling her up did not really reflect any fixation by you, because it really reflected a special situation where you thought she was in danger and that's why you had to keep calling her?
I did testify that those tapes that you played were not representative of the content or the kind of process that took place in an ongoing way in the relationship. Yes, that's true.
And would it be fair to say that you had not been compulsively calling her up to that point in time?
No, I think I testified that our agreement was that she wasn't able to call me at my home, and she also was not able to call me at my office. And so the agreement was, and her request was, that I call her very frequently. And I think I testified to all of that previously.
And you said you were concerned for her, and that's why you kept calling her only that one day.
I don't think I said that I only called her that one day at all. I think that it's already been established that there were many phone calls to her. And in fact, they were at her request and also they were the only vehicle through which we could communicate, and she wanted me to call her very frequently, and in fact got very upset and very insecure when I didn't call her frequently.
All right.
Very demanding.
And after you placed those phone calls, which the jury's heard, is that when you broke off the relationship and said, I can't any longer continue to comply with your wishes for me to come over all the time and call you up and take care of you?
I don't, the relationship, as far as I was concerned, was essentially, for all practical purposes, over long before that, from my standpoint. And the final asking her to leave the home was not the end of the relationship. The relationship, in my mind, had really, for any practical purpose, ended long before that.
All right, the court is going to strike the answer, and again, counsel, the inquiry has to do with the tape recordings, the audio recordings of the answering machine tapes, nothing to do with leaving the home. So let's focus on that time frame, please.
Well, you testified yes.
Couple questions here that I want to answer real quick. Sorry for pausing it. Curiouser. Sorry, I've had this saved for a bit. I've missed a lot of this series. Is multiple juries something still done? This is a very unique case. I've never seen multiple juries for any case ever outside of this case. So I think it's quite an anomaly. And David Puff asks, what is the point of this questioning? This guy is a scumbag. What does this have to do with the brothers' murder? It has to do with, on the one hand, the way that he characterizes his relationships with the other people around him. It can show the way that he's characterizing the communications and the relationship that he has with the brothers that can have an impact. But also this has maybe more specifically to do with the fact that he told her, the girlfriend, he disclosed to her what the brothers had told him. And there's this big question that the defense keeps pushing, is whether or not any of these disclosures were actually proper. Because even if the Court of Appeals said, yes, there is this in fact duty to disclose information if the psychologist thinks that there is a danger to someone's life, and that they, that there's an imminent danger to someone's life in not telling someone about something. They have this, they have a duty to warn. But even still, the defense has the ability to sort of like plant this in the jury's mind, and to say basically that, like this guy is going around disclosing things to people that he shouldn't have been disclosing this information to, including the girlfriend. He said all kinds of things about the relationship with the girlfriend. Like why is he pulling her into this case? Why is he pulling her into this whole situation, with these brothers? So it all kind of becomes this sub narrative, but it's not exactly on point, but it is related enough to be relevant. I hope that answers your question.
Yesterday that Ms. Smith was fixated on you. Do you recall that testimony?
Sustained. Let's focus on the area that was covered on redirect.
Well, I'm moving on to a new area that was covered.
All right. Well, then let's not regurgitate, go on to the actual question rather than going over the preface.
I was trying to do. Sir, do you recall testifying yesterday that Ms. Smith was pressing you not to be in the marriage?
Yes.
And do you recall you testifying yesterday that you broke off your relationship with her in early March of 1990?
Yes, I did.
All right. And in reference to that statement that you broke off the relationship with her in early 1990, isn't it true that even after the Menendez brothers were arrested, that you continued to pursue her and threaten her with the Menendez brothers?
I don't have any recollection of that and don't know what you're referring to.
Well, do you remember going over to her house? I think you testified in answer to questions by Ms. Abramson in cross-examination that you recall on or about March 19th, 1990, that you went to her house at a time when the police were on the premises and had put a body wire on Miss Smith. Do you recall that testimony?
Objection, the scope of redirect.
It is. Objection sustained.
Could I put your bench on?
Yes.
Thank you.
Um,
Dr. Oziel,
he has
getting
a
back
question
to the
here too.
subject-
I'm going to answer this real quick. Is it normal for a judge to make rulings without objections in place? Yeah. The judge can basically intervene, and if there's enough going on that the judge decides like somebody's got to sort this out here. The judge can get involved and basically like not make his own objection, but direct some traffic here and there. So yeah, it doesn't always happen. I would think most judges try not to do that, but here, I think he's getting a little impatient, I think, with some of the stuff that's going on in this courtroom today.
Subject here. Do you remember going after the police served a search warrant on your home on March 8th? Do you remember after that point in time, and specifically on March 19th, going over to Miss Smith's house to bring some of her belongings back to her?
Oh, that's correct.
And was that on or about March 19th?
I believe it was, yes.
And did you later learn through review of some documents that she had been, to use the phrase, wired for sound, and that the police had actually been in her house tape recording your conversation with her?
That's correct.
All right. And you've reviewed the transcript of those tapes or listened to the tapes, have you not?
If I did, it was 4 years ago. I haven't listened to them since.
And do you remember when you went to her house on March 19th, the first thing that you did was to try and embrace Judelon Smith, and she said, "I don't want any hugs."
Ooh.
And you said, "You don't feel like hugs?" And she said, "No." Do you remember that?
No, I don't, but that could have happened.
And do you remember one of the next things you said after you were talking to her was you said, "Well, first thing we have to establish is what kind of relationship do we have here, because you have not been acting like a friend." Do you remember saying that?
Yes, I probably did say something. I don't remember it, but I probably did say something like that.
And your statement that she had not been acting like a friend was in reference to her going to the police about the tape. Isn't that true?
No, it was in reference to things that she had been doing over a long period of time that were, I thought, extremely vindictive and vicious, and did not only relate to her going to the police.
And when you said, "Well, the first thing we have to establish is what kind of relationship do we have here, because you have not been acting like a friend," is it true that the following exchange took place? Smith, "Jerry, that is not the first thing we have to establish." And you then break in, "That's the first thing I have to establish, because you've been behaving really, just really." And Smith breaks in and says, "You mean there are other people out there who would want to kill me, and you're not going to tell me that?" And you say, "They probably want to kill me too, and you fell into this fix by what you did." And Smith says, "Why? Why?" And you say, "I tried to tell you that, and you wouldn't listen to me. I tried to tell you that you didn't know half the story, and you don't." Smith then says, "Well, maybe you should tell me so I can do know something, so I cannot do something stupid." And you say, "You already did something really stupid, really, really stupid." And she then says, "Well, the boys are in jail and I'm not dead. And you said that if I went to the police, I'd be dead in 2 minutes." And your answer was, "Guess what? It's going to be a little bit longer." Do you remember making that statement?
Objection, hearsay.
Overall.
I don't remember making the statement.
You don't remember making it.
I don't remember the specifics of that interaction. They might have taken place.
Not a surprising
And so
answer.
you might have said to her that, "Guess what? It's going to take a little bit longer," in reference to she's not dead yet.
Well, what I was saying is that I perceive that there is still a threat to her and to me.
And you were doing that for the purpose of manipulating her back into the relationship. Isn't that true?
That's what it
That's
sounds like.
absolutely false.
That's what it sounds like to me.
I was expressing anger at her putting us.
Objection overruled.
I was expressing anger towards her for putting myself, my wife, my children, and I perceived her in jeopardy. And as I already testified, the police had told me.
Objection, Your Honor.
I'm explaining why I made that comment.
You may finish your answer.
That the police had already told me that the fact that the Menendez brothers were in jail was not a guarantee of any kind of my safety. And in fact, I had been told that by numerous parties associated with the police department. And so my feeling of threat did not terminate at all with the arrest of Erik and Lyle. And I was expressing to Judalon Smith my anger at her having done this. She had been threatening to do it as a way of trying to get me to be with her. Specifically, she was threatening that if I didn't stay in the relationship with her, she would use the fact of her knowledge about the Menendez case, and she would go to the police. And then subsequently, as I've already testified, she signed a document.
Your Honor, I do think this is getting.
I'm explaining.
Yes, you've gone beyond the
Okay.
question at this point. All right, your next question, please.
He really takes as much as he can get to get
You
that
remember
extra
Dr. Oziel in
information
that
in
same
there.
conversation.
I can't say I
telling her
completely
that
fault him for
I
it.
received anonymous
He wants to
clear
tell that
threats from
story.
people that related to my life and had to do with me turning people in and had to do with me handling these tapes over. I said I did not hand the tapes over, and they were very clear references that when they found out who did hand the tapes over, that that person would pay, and that would be that for them.
Yes, I did.
Remember saying that?
Yes, I do.
And is it true that throughout this entire conversation, you kept making reference to people threatening the two of you
People did threaten me.
and connected with the Menendez brothers, according to you?
I did receive threats connected with the Menendez brothers, and it was reported to the police.
And was this meeting on March 19th something that you felt you had to do because she was again bothering you in the period between March 8th on or about the time when you broke the relationship off and the period of time when you had this meeting?
Yes, she was.
She had insisted that you come over on March 19th.
She had asked for me to come over March 19th, but it went beyond that. She was using other means of what I perceived to be extortion at that time.
Was she insisting when you walked in the door that you try and hug her and say that the first thing you wanted to talk about was your relationship?
No, what I was trying to establish is whether, in fact, there was any basis upon which I could trust anything she said. And I think that the entirety of that conversation will indicate that I revealed nothing about the Menendezes, disclosed nothing of content about Erik or Lyle, refused to talk about Erik or Lyle, refused to discuss any details throughout the conversation, having had no idea that she was wired about Erik or Lyle, said that I would not perjure myself at all, and refused to do anything but tell the truth under testimony. I think if you read the entirety of that police wiring, Mr. Burt, you would find that there were dozens and dozens of comments that related to the fact that everything I was going to say, if I was ever called upon to testify, was going to be the truth and only the truth, and that I refused to perjure myself. I don't think you read that part, Mr. Burt.
Your Honor, I'd like to move to strike the answer. This witness is becoming.
Okay, counsel, let's not make a speech. If you have an objection, the objection is a legal grounds.
Not responsive.
All right, let's have the question and what?
Multiple levels of piercing.
All right, let's have the question reread, please.
Question, all right, was she insisting when you walked in the door that you try and hug her and say that the first thing you want to talk about was your relationship?
All right, the objection is sustained. The answer is stricken, and you may answer the question.
No.
What a
Doctor,
simple
is it also
answer.
your testimony that you were not making the November 2nd, October 31st session in order to extort money from the Menendez brothers?
Absolutely.
And during this session on March 19th, do you recall you saying to Judalon Smith, Judalon, I'm trying to help you. I'm the only friend you have. You're not making it easy. I'm trying to help you. There's nobody else that cares about you. You're in trouble. I'm trying to help you. And Smith saying, Jerry, the boys did that by themselves. And you saying, Judalon, you don't know what you're talking about, and I can't tell you anymore. I tried to tell you before. If you want to believe that, then I'll just get out of here and leave you be and let you do what you want, okay? You're not going to know. There was $14 million involved in this. Do you remember saying that?
On which date?
March 19th?
I don't recall it.
Well, do you remember a statement specifically in reference to your saying there was $14 million involved in this?
No, I don't recall that specific statement.
Do you remember at the time you made the October 31st or November 2nd tape that it was your understanding that the Menendez estate was worth approximately $14 million?
I don't recall making the statement, but I might have made the statement. I don't recall it.
Objection not responsive.
Objection sustained. The answer is straight. Are you asking when he tape recorded his notes, or are you asking when the conversations on October 31st, November 2nd occurred?
The question was in reference to the time when you taped the notes.
When I taped the notes, the best of my recollection is that I stated that that's what Erik's statement was about the worth of the family estate.
So you had information from Erik that that's how much money was involved.
That's what Erik had told me.
And in general, would it be true that if you were making a tape for purposes of extortion, that the more harmful the tape, the better device it would be to use for extortion?
Sustained.
Yeah. But he still got that thought out there.
You
in front of the jury.
testified that at one point in the November 2nd or October 31st session, you offered two scenarios of different crimes.
That's correct, Mr. Bird.
And would it be fair to say that of those two scenarios, the one that you described as a premeditated murder scenario was, at least in your mind, the more damaging of the two in terms of incriminating them?
Objection beyond the scope.
Objection sustained.
On the scope of redirect. So he's got to stay within what they talked about on redirect.
Now, Doctor, you testified yesterday with reference to the packet of letters. Don't have the exhibit in court, but do you recall testimony about a letter that Judalon Smith sent to you that reflected what her solicitation of your business?
I recall that letter. Something
Approach
about
the
the letter.
witness, Ron.
Yes.
Is this a copy of the letter dated June 15th, 1989?
Yes, it is.
And I'm not sure what exhibit number that is, Ron, but the court reporter has it.
It's exhibit 120.
Thank you. That letter is dated June 15th, 1989, correct?
That's correct.
And is it your testimony that that was the first communication you had with Judalon Smith?
No, it isn't.
What was the first communication in terms of date?
Well, according to Judalon Smith, it occurred.
Objection on hearsay.
May I have the question read back, please?
What was the date?
Question, what was the first communication in terms of time?
Yeah,
All right.
According to
do you have
you.
a recollection of that? Of your
not
own memory?
according to Judalon Smith.
Not of my own memory, only
Right.
from a note from Judalon Smith.
All right. The objection is sustained at this point.
Yeah.
Can you use the note to refresh your own memory as opposed to just telling us what Judalon Smith says?
No, I can't.
Right, this you received on or about June 15th, 89?
That's correct.
And do you recall having any substantial dealing with her before June 15th?
Yes, I do.
And was that by way of phone or in-person meetings? What was it?
I think there were a large number of phone conversations beginning several weeks or so before that.
So
She asked me
maybe
to
from
call
the
her 10
1st of
times
June
today.
onward, or was it even before that?
Could have been before the 1st of June. I don't recall.
Was there any business dealings that you two had before this letter was sent on June 15th, 89?
Well, yes, there were.
What?
Well, Judalon Smith had broached the topic and made business propositions from the first phone call that she made. That was the point of the phone call. And subsequent to that, we had a number of conversations, and I don't remember the exact dates of them, but the conversations did in fact deal with business and business propositions and tape duplication and so on and so forth.
But was that
So real quick, question in the chat. It's a member chat, so it doesn't show up in StreamYard. Mantha Johnny, thanks for being a Bite Club member. Says, how do they actually strike something from the record? It's so obviously the jury is not going to unhear it, right? So the jury has heard it unless they're not paying attention, which is entirely possible. But what we're talking about is the record that is being developed by the court reporter, the court reporter or the stenographer. You know, they're taking down everything that's being said in the courtroom. And so when something is struck from the record, it's getting struck from literally the record that the court reporter is taking.
that just preliminary discussion, preliminary to this, what you characterize as her letter of June 15th, which basically formalized the business relationship?
No, I wouldn't state that. I would state that this letter was the first written solicitation letter, but it wasn't her first solicitation. She had solicited me for business purposes prior to that, perhaps as early as several weeks or so prior to that.
And had you come to any formal understanding with her, written or otherwise?
I don't know if it was a formal understanding. I think we discussed back and forth that she wanted to duplicate materials in my clinic, and she basically wanted to do this line of tapes. And so we had discussed it and the conditions under which that would have to take place. If it took place, so on and so forth, it would have to be confidential. She told me all about the FBI and all about her having done work, I think, also for the district attorney's office, and that everything that she did was strictly confidential, and she was used to working with confidential situations like therapy situations. And to the best of my recollection, all that took place before, and may have also taken place to some extent after this June 15th letter.
And is it true that the
Hang on, some follow-up questions here. Let's see here. So Mantha Johnny has a follow-up question, like, do they use whiteout in these older days, delete on PC now? I don't know. I don't think that the technology has really changed all that much for the court reporter's machine, but I don't know without actually talking to a court reporter that has been working in the field for a long time. But generally there's some sort of a mechanism to capture it. And then I don't think it's like a typewriter. It like immediately gets printed up, but I think it gets printed up at the end of the day. I know that that's how it is now. But yeah. I don't know how it was in the early 90s because, yeah, I'm not sure if that technology changed much or not since that time. And LaCoria says, so the strike has more to do with protecting the appeal. Yes, it is. It is much more about what is on the record for later use, either protecting the appeal or some other, motion at the end of trial to say that there isn't enough evidence that came in to support some element of some claim. That's usually how that might come in.
The June 15th letter then prompted you into a more formalized business relationship with her?
Well, no, that wouldn't be a fair statement, that alone prompted me into a more formal business relationship with her.
Well, when after this did you enter into a formal agreement with her where she was going to be duplicating your tapes?
As far as I know, I mean, it could have been any time from the first conversation to which we had, which would, prior to June 1st, whatever. I don't know what the date is. I don't recall it. In an ongoing way. She had been approaching me, and we had been.
I'm going to object to this point. The question was.
Counsel, if you have an objection, again, state the legal
Not
grounds.
responsive.
Let's have the question read back.
He's getting tired of it.
Question, well, when after that did you enter into a formal agreement with her where she was going to be duplicating your tapes?
All right, do you know when it was?
I don't recall a specific. I don't think there was a specific day. I think it was an evolutionary discussion.
Okay.
So you didn't.
And also, I don't know if you guys saw that, but the court reporter was reading back from the record. There's like a small printed tape. So this is how it's working. There's like a small printed tape that gets printed as she's typing. And it could be that she makes some kind of a note when something is struck from that record that, that literally gets written, is the judge saying like that last statement is struck from the record. So that might go to instructions later on. I'm not entirely sure on a practical level how that's going to work. I really want to find out now, but basically this little tape that gets printed, it then gets transferred over into like a normal transcript that reads like a deposition transcript that you may have seen something, floating around the internet that is like, it kind of looks like a movie script a little bit. But yeah, it's immediately printed out. It looks like, on this little tape that looks like a long receipt, as trial is happening.
I didn't mean to imply by reference to this letter in your redirect examination that this somehow was the first letter that prompted the whole relationship between the two of you.
No, I didn't. I meant it was only a written evidence of her soliciting me.
And in fact, there were dealings you had with her prior.
Yes, there were.
In fact, the confidentiality agreement, which is Exhibit 101, that's dated June 1st, 1989.
Yes, it is.
And did you date that document, or did she?
No, she did.
And was that an accurate statement as to when you entered into a confidentiality agreement with her?
I have no idea. She filled this out and she signed it and dated it, so I wouldn't have any idea at all whether that was accurate or not. You'd have to ask her. So
there may have been, and appears from that document to have been, some discussions prior to that letter of June 15th, 1989. Is that correct?
There were discussions, and I don't recall when she signed this document at all. It's her handwriting, her signature, and her dating.
Now, was the only reason you told Judalon Smith of the content of the October 31st and November 2nd session because you thought she was in danger?
I believe that was the primary basis. I also perceived at that time, because of the confidentiality agreement we had orally, and also this confidentiality agreement, that she was someone that I could disclose that information to, who would keep it confidential, which she obviously didn't. But the primary reason, and the reason that I disclosed it to her, was because I thought that she was in harm's way.
All right. And you would not otherwise have been disclosing what you considered to be confidential information to a non-confidential person?
No, I would not have.
You just don't do that as part of your practice?
Objection irrelevant.
Sustained.
You said that the information recorded on that tape of recording the sessions of October 31st, November 2nd did not contain inaccurate information, correct?
I don't believe that I stated that.
Well, let me ask you, did the tape of your notes contain inaccurate information?
I don't have any idea if there's some word or some statement somewhere that is inaccurate in the entire 20 pages of typewritten notes.
Well, were you intentionally trying to record inaccurate or false information, as I asked you before?
No, I absolutely was not intentionally trying to record anything, and I'm not aware of anything that's inaccurate, but that's not what you asked me.
And is what you told Smith based on what was in the notes?
To the best of my recollection, what I told Smith would have been a summary of things that I thought were important for her to know, for her to have enough information to appreciate the level of danger of the situation so she could make her own decision about what to do.
So the answer is that what you were telling her was basically what was reflected in your notes?
To the best of my recollection.
And I want to return, if I could, to an exhibit. I believe it's...
May we approach, please?
Yes.
Thank you.
Dr. Oziel, in reference to your testimony yesterday that Judalon Smith was fixated on you, was there a point in time when you took the shotgun away from her?
Yes, there was.
And why
Or
did
she
you,
gave it to me. I don't remember if I took it away or if she gave it to me.
why did you do that?
I don't recall I don't know how it came about that I got the shotgun back. She may have given it to me. I don't recall.
Oh, do you remember on
Oh,
March
Lucy with these
19th when you
shotguns.
two were talking and she said to you, but then you took the shotgun away and you said, excuse me, that's because you were in my house when you and I were talking about going away together and moving somewhere together, okay?
Whoa.
You were in absolutely, totally, I believed you to be in danger at that time. Do you remember that statement?
No, I don't remember it. I don't recall it. But if I took the shotgun away, I don't recall when that was. And it probably was because I thought she was in danger of harming herself with the shotgun.
You've just dragged your own speculation. Second.
Objection is sustained. The answer is non-responsive. The answer is stricken.
Did you talk to her at some point about going away and moving somewhere together?
Objection beyond the scope.
Can you specify a time frame, please?
But when you spoke to her on March 19th, did you say, when you and I were talking about going away together and moving somewhere?
Objection sustained.
In the period between October 31st, 1989 and March 8th, 1989, did you have a discussion with Judalon Smith where you two were discussing going away and moving together?
There was a discussion, I believe, that we had at one moment where I thought I might have to move away, and she wanted to move with me because of the danger.
And I think you said yesterday in your testimony that she was pressing you not to be in your marriage. Is that right?
That's correct.
And do you remember what period of time that pressing took place?
It took place on an extremely regular basis and sometimes on a daily basis.
From the point in time when you first became involved with her up to when?
No, from the point, I can't recall specifics, but I can basically state that from several months after the time that I first met her or talked with her, throughout a lot of the time that there was a relationship, she was pressing me to be with her and not to be with my family. And I was telling her very frequently that that's not what's going to happen.
That was not going to happen. And do you remember during that time period having a telephone conversation with her where she asked you, so how's the discussion going? And you answered, you pressure me every single minute of every single hour. You're so funny. And she says, you decided that before you knew me. And you say, yeah, but I didn't decide to do it like 7 months early because you couldn't stand to be one day without me. Were you speaking about a divorce there? First of all, did you make that statement?
I don't even recall having made it. And no, I don't think I would have been talking about a divorce, but
Do you
I don't
remember-
recall a statement.
Do you remember a statement in that same conversation where you said,
What is the date of this conversation purportedly?
between the period of October 31st and March 1990?
Objection is sustained. It's under section 352 of the evidence code.
Could I approach
Yes.
again? Thank you. Dr. Oziel, did you say
Quick
yesterday
approach.
that it's your belief now that Judalon Smith was present on November 2nd?
To the best of my recollection, she was present on November 2nd, and she could have been present on a night or one time after that as well. I don't recall, but I do recall that she was, I believe she came November 2nd against my instruction to her.
And did she indicate to you why she was coming?
She indicated why she came.
And what did she say in that regard?
Objection hearsay.
Do we have a foundation as to when this was stated to the witness, please?
Yes. Did you have a conversation with Judalon Smith prior to the November 2nd session?
Well, I had a conversation prior and after the November 2nd session.
Was there a conversation where you two discussed her coming to the office against your advice?
Yes, there was.
Was that an in-person conversation or a telephone conversation?
I don't recall.
Do you recall when it took place?
Just before the session.
That same day?
Best my belief or recollection, yes.
Where were you when you had this conversation?
Probably would have been, I think that whole period of time I was secreted at her house. So I might have been at her house, or I might have been, I don't recall where I was actually, just speculating or trying to guess about where I might have been.
And did you advise her that you didn't want her coming to the session?
I advised her that I thought that it was dangerous and unnecessary for her to come not to the session, to sit in the waiting room. She wasn't coming to the session.
And she said, I don't care, I want to come, or words to that effect.
I don't recall what she said or if she just came.
And did you two then go to your office at some point after that discussion?
You're referring now to November the 2nd?
Yes,
When he went to the office on that date?
correct.
Objection overruled.
Yes, I don't recall anything about what immediately happened before the session.
Well, you do recall she was there that day.
I have a vague recollection that she was there when I walked out of the session, and that's how I recall that she was there that day. I don't have any specific recollection of anything other than when I walked out of the session, as I recall, she was in the waiting room.
And did you walk out of the session with the Menendez brothers?
I do not recall that. They may have walked out first. I just don't recall. I'd be speculating.
Do you know if she saw them based on your discussions with her afterwards or that day?
Sustained.
Did you see Judalon Smith in the presence of the Menendez brothers that day?
She was in the waiting room and they walked out. So I'm assuming they could have seen her and she could have seen them. Yes.
Objection, Your Honor, speculation.
Objection sustained. The answer is stricken.
She was in the waiting room when they walked out.
That's correct.
And do you have to go from your office to get out the door? You have to walk by that waiting room.
That's correct.
Was there any shouting during that session of November 2nd?
Not that I recall. No. But I don't recall there being shouting either at the October 31st or November 2nd session.
And based on your knowledge of the way your office is set up, could you hear the content of what was being said between you and Erik and Lyle if you were seated in the waiting room on November 2nd, 1989?
To the best of my belief and my experience, the answer would be no.
And do you remember testifying at page 9871,
Volume
63,
line.
14?
Objection, irrelevant.
You're asking a question at 9871, is that right? Line 14.
9871,
You're asking that question of the
lines
witness?
14 through 20.
Objection sustained.
Whisper, 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 whisper. Like he's trying to figure out where's the next direction. Where am I going to go with this?
I think you testified yesterday that you looked to see if the Jeep had left when you went back to your office or before you went back up.
No, I didn't testify that. That's not correct.
Did you see both Menendez brothers leave in the Jeep on October 31st?
No, I didn't. I observed the fact that the Jeep was not there at the time the security guard escorted me to my car, and I drove out carefully, and the Jeep was not there.
So you didn't see them leave, is that correct?
I did not.
Now, lastly, Dr. Oziel, you testified yesterday to the fact that you were on probation, correct?
That's correct.
You also testified you were honorably discharged from the Army, was it?
That's correct.
What branch of the Army were you honorably discharged from?
The Army. The Army is a branch of the military services.
That's what it
Mr.
was,
Burt.
the Army?
Yes,
No,
Mr. Burt.
I apologize. I think my question was, you said you were discharged, but I don't think you said what you were discharged
I
from.
was discharged from the Army.
Thank you. And I think you said yesterday that you were on probation for an incident involving a patient named Court Day. Is that correct?
That's correct.
And you said that Court Day had formed a relationship with you, correct?
That's correct.
And you said that there was no attempt by you to exploit him in any way.
That's correct.
And you also said that you stipulated that what you had done in relation to Court Day was a technical violation, correct?
That's correct. That's how it was characterized to me by the supervisor involved.
And I think when you were testifying in Ms. Abramson's cross-examination, you were explaining how the gist of that violation was what's called a dual relationship.
That's correct.
And I think you also testified that a dual relationship is something that's not favored, but it's not necessarily a serious violation.
No, I think what I said is that the ethical code of the American Psychological Association states that that dual relationships are to be avoided because they have the potential for posing problems for the patient, conflicts of interest, and also give rise to occasions where there could be exploitation. So they are to be avoided. I didn't say that they were unimportant or that it wasn't a mistake to have been involved in that situation with Mr. Day.
And when you say something to be avoided, that's different from saying they're prohibited.
The language in the actual ethical statute at the time that this took place was they are to be avoided whenever possible, not that they are prohibited. To be avoided whenever possible is best as
Still
I can
sounds kinda
recall an
bad.
exact quote from the ethical code.
And what is your understanding as to why they should be avoided?
I think I just stated that it has to do with the potential for conflicts of interest and countertransference issues. And in addition to that, the potential
you already
for
said
there to
this.
be exploitation in the relationship.
Well, you said three things. Conflicts of interest. Would you explain what you mean by that?
Well, specifically, if a patient is in a dual relationship, and dual relationships do not only relate to employee, it could relate to treating a relative, it could relate to a number of different kinds of relationships where there simply are two roles that the therapist has with the patient. One being the therapist role, and the second being another role that could bring conflicts of interest into the situation. I don't know how to explain it anymore.
Okay.
than that.
And the other two things you said were exploitation, and what was the third one?
I said what are called countertransference issues.
What does that mean?
It simply means that the more that a patient's exposed to the therapist outside of the therapy relationship, the more it's easy for a patient to begin to have personal responses to the therapist that have to do with other important relationships in the patient's past, and that can sometimes be problematic in the therapy relationship.
And the third one you said was the exploitation potential. What does that have to do with it?
Exploitation just means the possibility or potential for a therapist to take advantage of a patient in some way.
Take advantage how?
It's nothing specific, it's just take advantage.
Well, it could be financially. That would be one way, correct?
Could be anything.
Could be sexual, would be another way.
I think I just said it could be anything.
but it would be anything that basically went beyond the bounds of what the person was properly there for, which is therapy, right?
That would be correct.
Okay. And you said that your understanding was that what you were involved with was a technical violation, correct?
That's-
Sustained. The answer is stricken. Yes.
Showing you exhibits 123 and 124. First of all, with reference to 123, do you recognize that set of documents?
Yes, this looks like the stipulation that related to this incident with Court Day.
Okay, and if you look at the last page, I think there is a document signed by you, is there not?
Yes, there is.
And does that document indicate that you have been provided with a copy of the stipulation and the other documents in the package, and that you've read and understand those documents?
I don't know. To the best of my recollection, I did receive this document at one time, but I don't know about any other documents I received.
Does the last page say, I have fully read and understand the terms of the above stipulation. I fully and freely accept its terms of settlement and hereby waive all rights which may be accorded to me. And then it goes on with some further.
I'm reading over your shoulder.
Yeah.
It appears to say that. It does say that.
It says, I understand that my license as a psychologist is revoked, that the revocation is stayed, that my license is placed on probation for a period of 5 years, and that I must comply with the terms of probation.
Oh,
I further understand that the terms of probation include an actual suspension of 1 month. I also understand that I must comply with the supervision requirements set forth in paragraph XB of the stipulation, and that termination of such supervision is contingent on the taking and passing of the oral examination portion of the licensing examination. And then it's signed Leon Jerome Oziel, PhD, correct?
That's correct.
All right. And then exhibit one, and that set of documents is from the Psychology Examining Committee of the Division of Allied Health Professions.
That's correct.
And exhibit number 124, can you identify that?
Yes, that's the behavioral science examiners. I don't even know that I ever saw this. Did I sign this? No, I didn't sign this. I've never seen this before.
Well, whether you know what it is.
It looks like a stipulation of the same exact decision. They simply have adopted it with the Board of Behavioral Science Examiners. I don't recall I've ever seen this. So,
Well, is it true, is it not, that you had, as I think you covered yesterday, 2 separate licenses? One was your psychology license, and the other was what's called an MFCC, which is Marriage, Family, Child Counseling License?
yes, I believe that I testified that they simply work together, and whatever the one board does, that the Board of Behavioral Science Examiners turn this over to the Psychology Board, and then whatever the finding was, they adopted it.
And in reference to the accusation from the Psychology Board, which is Exhibit 123, you'll see attached to 124, is the actual accusation by the Psychology Board, correct?
Correct.
And you've seen this before, have you not?
Maybe the last time I saw that was in 1985 or something of that nature. So I don't think I've seen that for probably 8 years.
And what it says here is that they were charging you with gross negligence, correct?
oh boy.
If you're reading it, if that's what they were charging,
We'll see.
yeah.
Take a look and see. If
Oh,
that's what
boy.
the accusation was.
Going through the details
that's a
here.
charge.
Okay. And the charge was that on or about June 1981, respondent commenced treating patient in individual therapy.
This is what the
This
defense
therapy treatment continued
wants
on
to
an
leave him with.
irregular basis, some weekly sessions, some marathon sessions on weekends, most sessions at respondent's office in Beverly Hills, but some sessions at respondent's home in Sherman Oaks on weekends until June 1982. During this approximate 1-year period, there was approximately 70 hours of therapy given by patient to respondent. When it became apparent to respondent that patient could not afford respondent's treatment fee of $95 an hour, respondent suggested to patient during August of 1981 that the patient, quote, work off, end quote, the cost of therapy by performing construction work at respondent's house located at 3744 Long Ridge Avenue. Then
That's
it
a different
details all the
characterization than
construction
what he
that
gave.
Mr. Day apparently did at your house, correct?
That's an allegation.
Right.
Definitely a different
Yeah,
characterization.
that's an allegation.
Well, and the allegation was that he designed, constructed, and installed a jacuzzi spa.
That's an allegation.
Was that true? Did he do that?
No.
He never did that. Did he do carpentry work on the eaves of your house?
I don't recall.
Did he remove trees in your yard?
I wasn't even there when he did virtually any of this, and I wouldn't know what he did specifically, except I certainly know that he didn't install a jacuzzi. He did perform, however, as I've stated, some work around the house, and I wasn't there when he did. And in fact,
I move to strike any that beyond personal knowledge.
Objection overruled. The answer will stand.
So
Did he install a sprinkler system?
I think I've just testified that I really wasn't even there when he did any of this work, and I don't know if he did or didn't install a sprinkler
I think he
system.
knows exactly
Well,
what
did
he
you at
did.
some point during the period of time that this allegation relates to come home and see that there was a new sprinkler system at your house?
I don't. This was 10 or
Do you not
12
pay
years ago.
attention
I
to
have
what's
no
going on
recollection
around your
of
house?
what work was done on a residence of mine that I'm not in 12 years ago at all. There was a large construction project ongoing with many different contractors and subcontractors, and Mr. Day was simply a handyman who was performing some tasks and not supervised by me and not at my direction.
All right, you said this is 10 years ago. You didn't mean to imply by that you had a lapse in memory as to what happened.
No, what I'm stating is that I didn't monitor Mr. Day, wasn't supervising Mr. Day's work, and I don't recall what day a sprinkler system was installed at a house when I wasn't even present 12 years ago. I wasn't even there.
Because when you gave your explanation yesterday, you seemed to have a good memory of your involvement with Mr. Day. To be a fair summary of your recollection.
Oh, I think I have a very good memory of my recollection of my therapeutic relationship with Mr. Day, but not of things that happened at my house when I wasn't present 12 years ago in relationship to a large construction project.
No, it says that the
Large
actions of
construction
respondent
project.
in serving as the therapist of the patient and also simultaneously serving as the customer of the patient in engaging the patient to perform the construction work that is listed in subparagraphs C and D on respondent's house were a violation of the dual relationship provision of Section 6A of the Code of Ethics of the American Psychological Association and amounts to gross negligence in the practice of his profession on the part of respondent. The reason for this is that respondent lost the objectivity that a therapist should possess toward his patient and allowed his personal feelings about the quality of the construction work being performed on his house by patient to interfere with the therapy that he, respondent, was attempting to perform with patient. That was the accusation, correct?
That was the allegation.
Right. And the board, at least the people responsible, the Attorney General's office brought this allegation, correct?
It's simply an allegation.
And at least the allegation wasn't characterized as a technical violation, was it?
Objection, calls for confirmation.
Overruled.
The allegation wasn't, but the stipulation was.
All right.
The agreement that we agreed upon, including the state agreeing upon, was something very different than what's stated in the accusation and the allegation.
And basically what happened is your attorney went in and made a deal, isn't that correct?
No, that's not correct.
That's not correct.
That's not how I would characterize it.
But wasn't there a period where your lawyer, long period of time where your lawyer was trying to negotiate with the MFCC board not to file charges against you and representing to them that you were in negotiations with the psychology board?
Irrelevant, Your Honor.
Sustained.
Now, turning to Exhibit 123. The stipulation itself, you agreed in writing to the following facts, which I'm going to read to you. During the period of time that began in June 81 and ended in June of 82, respondent treated patient CD in individual therapy. This therapy treatment continued on an irregular basis. On an irregular basis, some weekly sessions, some multiple sessions on weekends. During the course of treatment, respondent and patient agreed that patient would work off the cost of therapy by performing construction work at respondent's house. Patient did perform construction work at respondent's house during the period between November 1981 and November 82. The actions by respondent in serving as the therapist of the patient and also simultaneously serving as the customer of the patient and engaging the patient to perform construction work on respondent's house were a violation of the dual relationship provision of Section 6A of the Code of Ethics of the American Psychological Association, in violation of the provisions of Section 2960 of the Business and Professions Code. Respondent agreed to the dual relationship
I think
because
this is starting to
respondent
drag on, though.
believed the patient would not otherwise receive therapy.
I think
Is
that's,
that what you agreed to?
yes, I think that's entirely consistent with my testimony.
And where in there does it say that it was a technical violation, Doctor?
Rephrase the question, please.
Where in the documents in 123 and 124, if there is such a place, does it state that what you did was a technical violation?
Oh, sorry. Did not mean to pause it.
Doesn't state that in the document.
And they placed you on a period of probation for 5 years for a technical violation, correct, according to those documents?
I was told that it was a technical violation by the supervisor who actually was in contact with the board and who actually believed that I shouldn't have been on probation at all and tried to.
Objection, Your Honor. Testifying the only person who-
Objection overruled.
Well, was that included?
I
By the
wasn't-
way, it hasn't
I
finished.
wasn't finished.
Sure. Go ahead.
The supervisor, actually Dr. Lulow, the first meeting that I had with him,
Your Honor, I'm going to object this calling for hearsay.
Objection overruled. It's not offered for the truth, but as to the state of mind of the witness as to why he characterized this as a technical violation.
stated that he had never heard of anyone being disciplined for a dual relationship of this kind ever in the history of California. And he said that it was very frequent that therapists had dual relationships with patients and that they were not ordinarily disciplined. He then called the board and said, is there something about this situation that I don't understand? What did Dr. Oziel do that I don't understand that he's even on probation? This seems to serve no purpose. The board, according to Dr. Lulow, told him, there's nothing that you don't understand. It's simply that it got into the system, and the person who filed a complaint against Dr. Oziel happened to be on the ethical board and pressed hard for there to be an action taken because he's an ethics person. And Dr. Lulow then told those people
Sorry.
that he
Trying to
did
work
not,
my
and he wrote letters. Excuse me.
AirPods.
He wrote letters stating,
Excuse me.
Is there an objection, counsel?
Yes, Your Honor, now we're getting into multiple hearsay going in the other
All right,
direction.
none of this is offered for the truth of any of these things said by other people. It just reflects on why this witness has characterized this as a technical violation, and the jury is to receive it for that purpose only.
Dr. Lulow told me that he, after talking with the board and talking with numerous people at the board, he concluded that it was inappropriate that that I had even been disciplined for this. When he asked them what I did, and he asked them whether there was anything that was more serious than what he understood, he repeated what he understood.
Repeating himself.
Okay,
Objection overruled.
that the board said, no, it isn't any more serious than you think it is. It's just what it looks like. It's just he got into the system, and once he got into the system, there was no way to get him out of the system. So that's why he's on probation. And Dr. Lulow said to me, this is nothing but a technical violation. And he said, it's obvious it was a mistake, and it's also obvious you shouldn't be on probation. And he then proceeded to write multiple letters to the board requesting that the board terminate my meetings with him, not a call for me to take the examination. And as a matter of fact, there are 4 reports that he wrote to the board requesting them to
Objection,
remove
Your Honor,
me.
this is no longer what Mr. Dr. Lulow is telling
All right, the objection at this point is sustained. The witness has answered the question. Your next question, please.
And Dr. Oziel, after all this urging by Dr. Lulow and yourself, did the board take you on probation?
The board did not take me on probation.
Very much. And,
Oh.
sir, you didn't mean to imply by your testimony that that was a technical violation, that you weren't committing other illegal acts and unethical acts during the period of your probation.
Uh-oh.
Sustained.
One of the conditions of your probation was that during the period of your 5 years probation that you were to obey all laws, correct?
That's correct.
And you were supposed to be going to Dr. Lulu and reporting.
Dr.
Lulow?
Lulu?
No.
His name is Lulu?
His name is Dr.
Lulow.
Lulow.
I see. You were supposed to be going to
Dr.
him
Lulu.
as part of your probation and reporting to him any ethical problems that you might be having, correct?
That's correct, I believe.
And these letters that he was writing was basically, they were basically based on what you came out of the discussions you had with him about the nature of the problem, correct?
No, I would state that they came out of Dr. Lulow on a weekly basis, evaluating all aspects of how I conducted myself with patients and basically concluding that.
And that information that he had, which formed the basis of these letters, was in large part based on your meetings with him.
In some part.
All right. And what you weren't telling him was that you were continuing to violate the ethical codes of your profession during the period of your probation. Isn't that true?
Objection argumentative and this is argumentative.
Sustained.
Were you telling him during the period of time you were under his supervision that you were committing other unethical acts?
No, I wasn't.
And in fact, you were, though, weren't you?
I have no idea what you're talking about.
Well, were you committing acts in violation of both your probation and in violation of the law during the period of?
Why don't you get to some
Not
specifics?
that I'm aware of, Mr. Burt.
Well, would it be a violation of the law and a violation of your code of ethics to prescribe and send drugs to patients through the mail?
Objection, irrelevant, and I believe we've had a ruling on this already.
Objection under section 352 of the evidence code is sustained.
Right. And would it be a violation of your ethical code and a violation of the law for you to be attempting to extort money from a former patient by the use of tape recorded information?
Oh, boy.
I wouldn't know, but it sounds like it would, and that's nothing that ever occurred.
Right. And
All right, ladies and gentlemen, we'll take our morning recess and we'll resume at 15
All
minutes.
right. That is a good place to end it for the day. This was a bit of a longer session. The next one's going to be 3 hours and 15 minutes, it looks like, for the rest of this Dr. Oziel testimony. This has been a good one. It's Dr. Oziel, so we're talking about a lot of weird ethical issues. I cannot wait to hear from Judalon Smith, because I feel like we are going to have a completely different perspective on that relationship from her, and on the things that happened and her going to the police with the recordings and all that kind of stuff. But I am not convinced by most of the things that this witness has said. I mean, regardless, how does it actually bear on the overall outcome of the case? I don't know. I'm probably still leaning towards prosecution on this one, because I'm not entirely convinced that this expanded argument for self-defense is something that is legitimate, even though it does seem that there has been some real abuse of these guys from their childhood by their father. It's a very interesting case because of that. But yeah, this has been a fantastic divergence of Oziel v. Smith. And it's a side quest. Basically, that's what we're on right now is a side quest. It's a sub narrative that has somehow taken up so much time in this trial. But hey, it's been very entertaining. So at least there's that. So I hope you guys have enjoyed this, and thank you again to everybody that has been hanging out and watching with us. Thanks again to all of the mods who are helping to usher good conversation for everyone in the chat. And yeah, this has been another good solid session in classic trials. So yeah, I hope you guys have a great rest of your day or night, or wherever it is, and good rest of your week. And in the meantime, I'll see you guys in the next video.